Good afternoon, everyone. It is my pleasure to introduce you to the National Mooting Association of Antigua and Barbuda, which has been in existence for the past 5 years. Our dedication is to boost legal education and advocacy skills among aspiring law students across the OECS. As the organizing body for the Fortis Moot Court competition, we have provided a platform for Cape-level law students to engage in rigorous legal debate, understanding the criminal law, and of course, through mentorship, we will aim to cultivate critical thinking, persuasive communication, as well as a passion for justice in the next generation of legal professionals. In our 5th year, we are pleased to have participating, of course, from the Antigua and Barbuda State College. We also have students from the T.A. Marisho Community College from Grenada, as well as participants from St. Vincent and the Grenadines Community College. Now this year, our fact pattern is a criminal law-based fact pattern, and I will read through the brief quickly before we begin the competition. It is titled Adima Vibes Skilly Parker Against the Crown. Adima Vibes Skilly Parker is a globally celebrated DJ and music producer from Antigua, famous for his unique sound that blends Caribbean beats with the contemporary rhythms. Known for his charisma and compelling lyrics, he has millions of followers around the world and holds a near mythical status in his homeland. Yet his life is now under scrutiny as he stands accused of orchestrating the murder of his childhood friend and longtime collaborator, Jerome Blizzard Thompson. Vibe Skilly and Blizzard rose from humble beginnings in St. John's, Antigua. They met in the Princess Antonary High School, bonded over a shared love for music, and eventually became a powerful duo in the music industry. While Vibes was known for his larger-than-life personality and stage presence, Blizzard was known as the quieter, yet equally talented half of the pair, often focused on the production and technical aspects of their music. In recent years, however, their relationship had soured. Rumors circulated in the industry about their ongoing dispute. Blizzard felt overshadowed and exploited, while Vibes was frustrated with Blizzard's demands for more recognition and financial compensation. Close friends and colleagues recalled heated arguments, and some hinted that the duo was on the verge of dissolving their partnership. On the morning of May 16, 2024, Blizzard was found dead in his luxury villa in Jolly Harbor at approximately 6:30 a.m. by his housekeeper. The pathologist, Dr. Maria Smith, performed a post-mortem and determined that the cause of death was blunt post-trauma to the head. There were signs of a struggle in the villa with broken glass and overturned furniture. The previous day, Vibes Skilly went to the villa to discuss business, and according to Vibes, they argued over financial matters and the future of their musical partnership. He stated that he left around 6 p.m., but the prosecution witness, Sandra Harris, claims otherwise. Sandra Harris, a longtime friend of both men and Blizzard's neighbor, claims to have seen someone who resembled Vibe Skilly driving towards the villa at around 8 p.m. Sandra said she was driving home in the rain and saw a dark-colored vehicle speeding in the direction of where the deceased lived. The roads were brightly lit, but it was raining heavily. She said that she observed him for at least 5 seconds and that the vehicle was untinted. She had known the accused for at least 15 years. Now, the prosecution reported that neighbors heard loud voices and sounds of an argument from Blizzard's villa shortly after 8 p.m. One neighbor, Nosy Nancy, claims to have heard Blizzard shouting, "You can't control me, and you'll never get away with this," followed by a voice she believed to be Vibe Skilly replying, "You're nothing without me." Nancy says she knows his voice because she listens to his music as well as watches his interviews. On May 16th, The police arrived and at the home and charged him with the murder of Blizzard. His fingerprints were on an award plaque believed to be the murder weapon, and the defense countered this by saying that while he was at the home at the previous day, he held the award while reminiscing on the earlier days of his partnership with Blizzard. As the high-stake trial continued, a few jurors, already weighed down by the intense public scrutiny, started to feel pressure beyond the courtroom walls. One evening, after leaving the court, juror number 7, Cindy Shaky, said as she left Cost Pro supermarket, a stranger leaned in close to her, and his voice, barely above a whisper, but dripping with threat, said, "Gyal, make sure you do the right thing." She felt a chill as the man gazed lingered and his words heavy with menace. She did not tell the other jurors, but informed the registrar of the High Court, who then informed the judge. The judge, while summing up the case, without mentioning the encounter to the entire jury panel, instructed them to stick to their oath and to make the decision based on the evidence that they heard in court. The jury returned a guilty verdict, and the appellant, Vibes Skilly Parker, now appeals on the following 3 grounds. The first ground, whether the reliance on the ID evidence of Sandra makes the conviction unsafe. Issue 2, whether the circumstantial evidence relied on by the prosecution was sufficient in grounding the conviction. And thirdly, whether the judge should have discharged the jury after a complaint by the juror was brought to his attention. So as I said earlier, there will be 4 rounds this afternoon. There will be no rebuttals. And the first round will be Team 103 from Antigua and Barbuda. They are the respondents. The second round will be Team 108 from Antigua and Barbuda, respondents, and 113 from St. Vincent, who are the appellants. The third round will be Team 109 from Antigua, who are the appellants, and the respondents are Team 110 from Grenada. And the fourth round will be Team 101 from Antigua as the appellants, and Team 112 from Grenada as the respondent. Of course, the teams will be excused from the courtroom until their round is called. So without further ado, we'll now call forward Team 103, the respondent team from Antigua and Barbuda.
So 103 is Antigua, and who's the other one?
There is no opposing counsel.
Okay.
Good afternoon, ladies and gentlemen. Good afternoon, contestants. Before I start, I'd like to introduce the panel before us this afternoon. We have the attorney in the DPP's office, Attorney Rashida Jones. We have Magistrate Mighty, a current sitting magistrate. We have Mr. Williams, attorney in the DPP's office, and myself, Mrs. Hyman, a former chief magistrate. So when you're ready, you may start. Thank you. Don't be nervous when you're ready.
They're going to introduce themselves. Okay, I would expect.
Your lordships, your ladyships, if it pleases the court, I, Timothy Matherin, appear on behalf of the prosecution, and I am joined by my colleague, Leanna Brown. We, on behalf of the prosecution, submit that the appellant, Adema Vibes Skilly Parker, is in fact guilty of the murder of Jerome Blizzard Thompson, and that his conviction should be upheld. We submit that the identification evidence is reliable, that there was motive to kill, and that the jury should not have been discharged. With the leave of the court, may I proceed with my submission?
Certainly, you may.
The submission that I shall present is the identification evidence is reliable. The prosecution submits that the identification evidence provided by Sandra Harris is both credible and sufficient to support the conviction. It is important to acknowledge the guidance provided by Turnbull versus the Crown in 1977, which offers a framework for assessing identification evidence. In this instance, Harris's testimony meets the necessary legal standard. Your Lordships and Ladyships, the Turnbull case advises caution, particularly in situations where the identification of the accused is central to the prosecution's case. However, it is highly important to acknowledge that Turnbull offers a framework for evaluating the quality of identification evidence. This framework ensures that a careful examination of the circumstances surrounding the identification is required. Now, the visibility conditions did not prevent the identification. Harris identified the appellant while driving in heavy rain, but her testimony continues to remain reliable. Although the conditions were not ideal, they did not completely shroud her view. She observed the appellant through an untinted car window and recognized him through familiarity. The Turnbull guidelines emphasize that identification evidence must be assessed in context and therefore cannot be outright dismissed.
Can I just ask you a question, sir? Mr. Mathrin? You don't think the heavy rain could have made a big difference to the visibility, and she was driving, so was she concentrating in those circumstances?
Your Ladyship, I firmly assert that because of the untinted car window and the street lights, she was able to see the appellant very well. The jury was properly directed to consider the conditions under which Harris made her identification, and they found it compelling. The prosecution contends that while the weather conditions were indeed unfavorable, they did not negate Harris's ability to identify the appellant. Harris had the opportunity to observe the appellant, and her recognition was grounded in familiarity. Furthermore, the Turnbull guidelines themselves urge a contextual analysis. The guidelines do not establish a blanket rule against identifications made under less than perfect conditions.
I'm sorry to interrupt. You said familiarity. What do you consider to be the familiarity with which she was which he would recognize him?
Your Ladyship, Sandra Harris had known the appellant for more than or around 15 years, and therefore this should be enough to submit that she was familiar with the appellant.
Okay, thank you.
But in what context, though? Familiarity over 15 years, but what was the degree of familiarity over that time period?
Your Lordship, we submit that Sandra Harris was indeed very familiar due to past experiences and being known as, Your Lordship, as stated in the briefing, Your Lordship, as stated in the briefing, the sufficient time in which was given was about 5 seconds.
And would you say 5 seconds is sufficient time to make an observation?
Yes, Lordship, Your Lordship, in terms of the other circumstances in which she was familiar with him beforehand, it is highly believed or known that she was able to recognize him in that amount of time.
Mr. Mathrin, when you take everything into consideration, so the weather conditions, it was at night, and also the 5 seconds, was that sufficient to ground that identification, proper identification of Mr. Vives, Scaly Parker?
Well, of Harris's sighting. However, psychological research demonstrates that the recognition of familiar individuals can occur in mere moments. So Harris was already acquainted with the appellant, meaning her identification was not a mere guess, but an informed recognition. Furthermore, Harris promptly reported her sighting, reinforcing the credibility of her testimony. Any delays in formal reporting do not negate the reliability of her eyewitness account, but may instead reflect that there is a natural amount of time to process shocking events. In addressing the matter of the sighting's duration, the prosecution submits that the critical factor here is recognition and not mere identification. As the case of Beckford and Shaw of 1993 clarifies, there is a distinct difference between identification and recognition. Recognition, particularly of a known individual, can occur swiftly.
But may I ask, even though it's the case of recognition, as you say, could it not be a mistaken recognition as well?
Well, Your Ladyship, as a prosecution, we submit that based on the other circumstances or the other facts, it is highly unlikely that this was a mistaken recognition.
And tell me more, why do you say so?
Well, as I have presented here, because of the untinted car window and also the fact that she is familiar with him, and also the duration of which she was familiar with him, which would be around 15 years, I assert that this could not just be a mistake.
Very well.
Harris's familiarity with the appellant strengthens the reliability of her recognition. The fingerprint evidence is highly pervasive. The presence of the appellant's fingerprints on the award plaque directly connects him to the scene. His explanation of handling the award plaque at an earlier date is uncorroborative and speculative. Forensic evidence does not require time-specific certainty to be compelling. It merely needs to establish a logical and credible link between the accused and the crime scene. In Brown versus the State of 2022, the court emphasized that forensic evidence, when supported by other incriminating circumstances, carries significant weight. The Crown versus Galbraith does not suggest that forensic evidence is inherent.
My apologies, I didn't hear the name of the case. Crown versus?
The Crown versus Galbraith.
Galbraith, okay. Continue, sir.
So this case does not suggest that forensic evidence is inherently unreliable, but rather that weak evidence should not sustain a prosecution. Here, the fingerprint evidence is not weak. It is a critical part of a broader evidentiary framework proving guilt. To further emphasize the significance of the fingerprint evidence, the prosecution draws the court's attention to the principle that circumstantial evidence, when considered in its totality.
Let me just ask you a question. As it relates to the reliance on the identification evidence of Sandra, while there was no evidence that an identification parade was done or wasn't done, would you say an identification parade would have served a useful purpose as it relates to Sandra's identification of Mr. Vibes Skilly?
Yes, Lordship. I believe, or I assert, that it would have served a helpful, it would submit help towards the identification provided by Sandra Harris. However, we assert that it was not particularly needed.
I see. Very well.
Okay.
And why wasn't it needed?
Okay. Your Lordship, based on the evidence that we have provided, or the familiarity, therefore, which she has known him for a very long time, had recognized him through an untinted car window, we assert that it was not needed because she had already gained enough information to recognize him properly.
Continue.
Thank you. To further emphasize the significance of the fingerprint evidence, prosecution, once again, draws the court's attention to the principle that circumstantial evidence, when considered in its totality, can be compelling. As Pollock CB noted in the Crown versus Excel of 1866, circumstantial evidence can be likened to a rope comprised of several cords. No single strand may be sufficient on its own, but collectively, they can establish a strong conclusion. The fingerprint evidence, coupled with other evidence, forms a robust cord. The voice identification further supports the prosecution's case. So, the testimony of Nosy Nancy regarding the argument she overheard is relevant and admissible. While there may be attempts to undermine voice identification, courts have routinely accepted such evidence when witnesses are familiar with the suspect's voice.
And just before you continue, what Nosy Nancy said she heard were about 4 words. Legally, would that be enough to establish a proper voice identification?
Your Lordship, coupled with the fact that Nosy Nancy is a familiar person to the appellant, being his neighbor, it is firmly asserted that this was enough, or these words, few words, were enough to support her testimony.
Very well.
Okay.
If I may, are you familiar with the work of, you may not be familiar with the work of Sherin out of Canada, but what it establishes is that oftentimes an empirical test has been done in terms of family members, and oftentimes wives mistake the sound of their own husband's voices over the phone or when played to them. And this research seems to indicate that ear witness identification is even more problematic than eyewitness identification. So here we're talking about 4 words, is it? 4 words. In the context where there is no evidence, well, we know that the witness has been a regular viewer of interviews. But tell me, in light of the known problems, inherent problems with ear witness identification, what particular aspects of this particular case would you say substantiate the reliability of this particular ear witness identification?
So, Your Lordship,
Yes.
as you had mentioned earlier, Nosy Nancy is familiar with the appellant through not encounters, but interviews. But she is also familiar with him through personal encounters, and she is familiar with him through his music. To speak about the problem where they may mistake a known person's voice for someone else, we submit that in this case, because of the familiarity, or the strong familiarity, we believe, or no, we assert that she had not made a mistake and was clearly affirmed and knew that this was the appellant.
If I could just follow on from that point, do you accept that hearing me speak and hearing me sing can be totally different, given the fact that we have sound engineers who can do all sorts of things with voices? So even though you are familiar with my speaking voice, my singing voice may be totally different. Do you accept that? That's a possibility.
Yes, Your Ladyship, that is a possibility. However, due to personal encounters, which was stated earlier, we affirm that she had a clear understanding of his voice. Okay. The Crown versus Forbes of 2001 does not establish a blanket exclusion of informal identification. Rather, it reinforces the importance of evaluating identification reliability on a case-by-case basis. In addressing the matter of voice identification, the prosecution submits that the reliability of such evidence hinges on the witness's familiarity with the voice in question. As noted in legal precedent, the cogency of voice identification is directly proportional to the witness's degree of familiarity with the accused's voice. Now, as stated earlier, Nancy was familiar with the appellant's voice through music and personal encounters, making her recognition valid. The absence of a recording does not diminish her ability to recognize a known voice in a heated argument. Nancy's familiarity with the appellant's voice, gained through listening to his music and personal encounters, provides a reliable basis for her identification. While a recording would provide additional evidence, its absence does not invalidate Nancy's testimony. My ladies, my lads, if it pleases the court, this is the extent of my submission.
Thank you very much,
Thank
Mr.
you, sir.
Matthew. Thank you.
At this stage, my colleague Leanna Brown will continue with her submissions.
Thank you. When you're ready, Ms. Brown, you may commence.
My lads, my ladies, if it pleases the court, I, Leanna Brown, appear on behalf of the prosecution. I will expound on the other submissions that there was a motive to kill and the jury should not have been discharged. With the permission of the court, may I proceed with my submissions?
Certainly, you may.
Firstly, regarding motive. The motive for the alleged murder of Jerome Blizzard Thompson is intricately tied to his deteriorating relationship with Edema Vibeskilly Parker, his childhood friend. The two men, who had once been a successful musical duo, began to experience significant tension in their relationship in the years leading up to Blizzard's death. According to rumors circulating within the industry, Blizzard felt overshadowed by Vibeskilly's rising fame and growing influence, while Vibeskilly felt frustrated with Blizzard's demand for more recognition and financial compensation. These disputes reportedly led to heated arguments, causing their relationship to be on the brink of dissolution. This growing animosity forms the basis of the prosecution's case, which argues that the motive behind Blizzard's murder stemmed from these unresolved conflicts.
Ms. Brown, I'm so sorry to interrupt you, but I just want for you to clarify for me whether rumors are sufficient enough to truly establish motive. Whether rumors are sufficient enough to establish motive to kill.
Lady, I submit that the rumors were sufficient enough to provide motive, as these conflicts were continuous and repetitive, and it is easy to show motive for someone to kill when there is ongoing conflict.
Carry on, counsel.
On the day of the murder, Vibeskilly reportedly went to Blizzard's villa to discuss their business matters, during which they had a heated argument about their musical partnership and financial issues. According to Vibeskilly, he left the villa around 6 p.m., but a key witness, Sandra Harris, claims to have seen someone resembling Vibeskilly driving towards Blizzard's villa around 8 p.m. The prosecution further strengthens the argument for motive with a testimony from a neighbor, Nosy Nancy, who heard a loud argument between the two men. The neighbor claims to have heard Blizzard shouting, "You can't control me and you'll never get away with this," followed by a response from someone she believed to be Vibeskilly saying, "You are nothing without me." This exchange suggests a deepening resentment and frustration, with Vibeskilly potentially feeling betrayed and threatened by Blizzard's actions and demands. the discovery of Blizzard's body with signs of a violent struggle, along with the fact that Vibe Skilly's fingerprint was found on an award plaque believed to be the murder weapon, further implicates him. While the defense argues that Vibe Skilly merely held the award in a nostalgic moment, it adds to the circumstantial evidence that ties him to the crime scene. Taken together, the history of conflict between the two men, the heated argument the night of the murder, and the physical evidence, it points to a strong motive for Vibe Skilly's involvement in the murder of Blizzard.
Sorry to interrupt you, Counsel. I have a question. You're relying very heavily on Nosy Nancy. Now, Sandra Harris saw a car around 8 o'clock driving, and then Nosy Nancy says shortly after 8 o'clock. Do you think there could be any gaps between? Are they clear about the times when these things occurred?
Milady, I don't believe there was a time given for when Nosy Nancy heard him, but I don't believe that there is any gap in the time.
Well, I believe I heard that shortly after 8 o'clock he got there, then she heard the noise. So we don't have any idea if there's 5 minutes, 10 minutes, or how long it is alleged Mr. Vibe Skilly was in the property.
No, milady, that was
Okay,
not
thank
provided.
you.
I have one question in relation to that. I hear you making heavy weather of the discrepancy between.
Pardon me?
I hear you making heavy weather. Does that necessarily lend itself to the inference that he's lying to cover up his involvement in the crime? Address the court on that issue.
I'm not sure.
Even if the fact that there's a discrepancy between Vibe's indication that he was there at 6, or not thereafter, not after 6, not at 8 p.m. If the dissonance between Vibes placing himself there at 6 and the witnesses placing him there 8 p.m. and thereafter, if that lends itself to the inference that Vibes is lying, where does that take you? Does it necessarily mean that he's lying to cover up his involvement in the crime? Could it not be that he's lying because he's ashamed of just how it looks for him to have been there, period?
My Lord, we believe that we submit that it would most likely be a situation of him lying to cover up the murder, given all the other evidences, such as his conflict with Blizzard and the reports of him threatening him.
Okay. Carry on.
The prosecution asserts that the strained relationship between the accused and the deceased, marked by frequent arguments about money and recognition, play a crucial role in leading to the fatal argument that resulted in the murder. Drawing on the principle in Ball 1911, the prosecution argues that proving previous acts or words that show the accused harbored feelings of enmity towards the deceased not only establishes a malicious intent, but also strengthens the circumstantial case that the accused killed the deceased. The prosecution contends that it is more probable for a person to be killed by someone who has motive, such as ongoing conflict, than by someone without a clear reason to act violently. The second issue concerns juror misconduct and whether the judge should have discharged the jury after a complaint raised by one juror. In Campbell versus the Crown 2024, the court emphasizes that judges have a broad discretion in handling all allegations of juror misconduct. The judge must determine whether the misconduct was serious enough to compromise the fairness of the trial, and if so, whether it warrants discharging the jury. The judge should not have discharged the jury in this case for several reasons, mainly rooting in the lack of substantive evidence that the alleged intimidation of juror number 7 had any influence on the verdict. While the defense claims that the jury's impartiality was compromised due to an intimidating encounter involving juror number 7, there is no clear evidence that this incident affected the juror's ability to deliberate fairly or that it influenced the overall verdict.
Ms. Brown, Just to clarify, do you not believe that the judge should have made inquiries into this incident involving juror number 7 before you make such statements?
Yes, my lord, the judge did in fact make inquiries about the intimidation and found that a warning would have been appropriate, which I will speak about further in my presentation.
I have a follow-up question. I must be mistaken, but I hear you say there is no clear evidence in terms of this affecting the jury's deliberations. Is that what you're saying?
Yes.
And you cite the authority of Campbell against the Queen. Does Campbell and the Queen stand for that proposition? That there must be clear evidence? Is it not a fact that very early in one's tenure as a law student, you learn that justice must not only be done, but must be manifestly and clearly be seen to be done? Therefore, optics matter. Is it that clear evidence has to be substantiated, or is it the optics? The optics itself is a problem. Address the court on that. Sounds are short of clear evidence. The optics, though, in terms of the administration of justice for reasonable members of the community, seeing this and recognizing this likely evil, and for it not to be met with due focus on the part of the trial judge, instructions, and seeking to find out how this would have affected the juror and whether it was communicated to their fellows.
It can be, my lord, it can
Yes.
be assumed that this situation did not have any influence because juror number 7 did not communicate with the rest of the jury about this issue. She went to the judge, and the judge investigated it and decided that it was not admissible in terms of it affecting the fairness of the trial.
But what was done in relation to the other jurors in terms of ascertaining the extent to which they became privy to this at any point? Was anything done in that regard?
The judge, as I will speak about further in my presentation, the judge gave instructions to the entire jury.
Okay. Continue, carry on.
The prosecution argues that the jury's impartiality was maintained and there is no indication that the incident led to any prejudice or bias. The judge acted appropriately by instructing the jury to stick to their oath and base their decision solely on the evidence provided in court.
If I may interrupt, sorry, I just want to say, given that this is such a high-profile case, obviously there's lots of media attention, do you not think it would be even more important, more decisive for the judge to decide that there should be nothing at all to taint the jury? Because if a jury felt threatened, then clearly there's an element of tainting the jury. Do you not think it would have been wise to have a new jury pool, have a new jury, given the fact that it's such a high-profile case? And justice must not only be done, it must be seen to be done, as I'm sure you're aware.
The prosecution, my lady, the prosecution submits that what the judge did was correct, and given the fact that the judge has the discretion to make such decision, I believe that the decision was fair.
And you think the judge's decision would bolster public confidence in the jury system? Because, as I said, it's a high-profile case, so the public must feel confident that the jury system is clean and not tainted in any way whatsoever.
Yes, I believe that.
Thank you.
In cases like Brown versus the State, 2022, the court establishes that while jury integrity is of utmost importance, speculative claims of bias or intimidation do not automatically warrant discharging the jury or overturning a conviction. The standard for overturning a verdict due to jury intimidation is clear and requires substantial proof of coercion or influence, neither of which are present here. Additionally, the jury's ability to deliberate independently was not impaired. The fact that the jury received appropriate instructions from the judge to focus solely on the evidence further supports the argument that the deliberation process was not tainted by the intimidation. Given the absence of any concrete evidence of coercion or undue influence, there is no basis for discharging the jury. The way the judge handled the situation, coupled with the absence of any demonstrable harm to the fairness of the trial, reinforces the notion that the jury's verdict should not be questioned or overturned. We, the prosecution, rely on the circumstantial evidence of motive and defends the judge's decision to keep the jury intact.
Just before you continue, from a legal standpoint, are you saying that the directions given by the judge were sufficient to address any potential prejudice that may arise from the threat that juror number 7 received?
Yes, my lord.
Where are you getting that from? What is your authority for that?
As I stated before, according to Campbell versus the Crown, the judge has full discretion over jury misconduct matters, and given that this intimidation was only to one juror, I believe that the judge's decision to remind them to stick to their oath was in fact sufficient.
Very well.
Follow up to that. So you ground your submissions on the authority of Campbell versus the Queen. Now, of course, you would know what obtained, what the Privy Council handed, what the decision was. What distinguishes the instant case from Campbell?
Pardon me?
What distinguishes the instant case from Campbell? Why shouldn't the holding in Campbell be applicable in this case?
Because, well, in Campbell versus the Crown, it was also a high-profile murder case where it was said that the jury was intimidated, and after the judge did their deliberation, it was decided that the jury should not have been discharged because the judge gave the jury sufficient instructions. So, given the similarities between the circumstances of the case, that is the reason why
Okay.
we, the prosecution, humbly and respectfully submits and asks this honorable court that the conviction against the appellant be upheld on the ground that the identification evidence is reliable, there was motive to kill, and the jury should not have been discharged. My lads, my ladies, if it pleases the court, this is the extent of my submission.
Thank you very much, Mrs.
Thank you.
Brown. Thank you.
Shouldn't we be given some time to do the assessment prior to? Because didn't you say that it's best to make sure you do the grading immediately after? So at most, what,
5 minutes at the
5
most.
minutes or so? Let's do that.
Yeah. Good afternoon, contestants. When you're ready, you may begin. Give me the appellant.
Good afternoon. May it please this honorable court, my name is Adia Daniel, and alongside me today, Adia Daniel,
Alia?
Adia Daniel, and alongside me today is my co-counsel Chad Keyser, and we appear on behalf of the appellant Adema Skilly Parker in this matter. It is often said that justice must not only be done, but it must also be seen to be done. Yet, in this case, justice has not simply hidden behind a veil. It has been swept away in a torrent of rain, guesswork, and gossip. My ladies, my lords, we appear before you today not to distort the facts of this case, but to defend the law, to rescue it from the very real dangers of mistaken identity, flimsy circumstantialism, and jury intimidation. Dangers so glaring that even you, my lords, my ladies, would reach for your blindfolds and asked, wait, what? Adema Skilly Parker stands not as a man justly convicted, but as one wrongfully condemned on a foundation of tenuous evidence. The prosecution would have this court believe that amidst a raging storm, through blurred vision and uncertain memory, a neighbor suddenly exhibited hawk-like precision. That fingerprints on an award, a plaque, not a weapon, somehow proclaim guilt. And that a whispered threat to a juror is merely an inconvenience, not an obstruction to the essence of justice. In the minutes ahead, my co-counsel and I will walk this honorable court through 3 fatal flaws that infect this conviction. 1, the unreliability of Sandra Harris's fleeting and uncorroborated identification. 2, the speculative, insufficient nature of the circumstantial evidence presented. And 3, the trial judge's grave failure to protect the sanctity and safety of the jury. With the relief of this honorable court, I will address argument 2, and my co-counsel will speak on arguments 1 and 3. Each of these on its own would undermine the fairness of any trial. Together, they do more than that. They obliterate it. The duty before this court here today is not complicated. It is to see the truth and to return the only verdict consistent with justice, not guilty. This is not a question of emotion or presumption. It is a matter of law and of the fundamental principle that no one should be convicted unless guilt is proven beyond reasonable doubt. Therefore, I urge this honorable court not only to examine the law, but to sense its pulse, to acknowledge that a conviction rooted in shadows, speculation, and fear cannot endure in the light of justice.
I'm sorry to interrupt. Can I just ask you a question? Is it not possible that if you've known someone for 15 years, you could recognize them from a distance from walking behind?
Respectfully, my lady, familiarity, it doesn't make up for common basic human error.
Thank you.
And in case law, if you would allow me,
Certainly.
We see that identification in extreme and difficult circumstances and factors such as the ones presented in this case, we have to be cautious with Sandra Harris's story.
Thank you.
We respectfully ask that this honorable court quash the conviction and enter an acquittal verdict because justice, real justice, demands it. My ladies, my lords, on the grounds of insufficiency of circumstantial evidence, a criminal conviction requires a strong, unbreakable chain of reasoning. It must rest on a solid, logical sequence. Here, the prosecution presents broken links loosely tied together by assumption and speculation, not the certainty and substance that the law requires. The Crown's case hinges on a fingerprint on a music award, an overheard argument, and the prior disputes between the deceased and the accused. But these pieces, taken separately or combined, do not amount to proof beyond reasonable doubt. Let me begin with the fingerprint, found not on a weapon, but on a plaque. Mr. Thompson's home was a shared space.
Ms. Dan, I'm sorry to interrupt you again. Are you suggesting that a plaque could not be used to kill someone or do some serious damage?
No, I actually agree with you. It can. But in this case, this plaque was shared between the two, the deceased and the accused. It was an award that they would have both won. And so a fingerprint and even the use of the plaque is just not, in this case, that relevant, especially because we have seen or heard or we were told that upon investigation of the scene, there was broken glass on the floor.
Okay. Thank you.
Mr. Thompson's home, this was a shared space. Mr. Parker was a frequent visitor. Let us not forget that they were friends. It's unsurprising and probably even expected that his prints would be found there. Mr. Parker admits to handling the award during a visit to reminisce with the deceased. His presence was routine and unremarkable. Secondly, the prosecution will also point to the argument overheard by Nosy Nancy, where Parker allegedly said, "You're nothing without me." Heated words, perhaps. The prosecution will argue that this is incriminating, but it is hardly incontrovertible incriminating evidence. The prosecution claims that it evidences motive. Artists quarrel, yes. Creative tensions are common, yes. Disputes.
If I may,
Sure.
just to be clear, are you conceding that this quarrel, the alleged utterances, were in fact made by your client?
Yes.
Okay. Okay. Thank you.
Disputes in business, especially with lifelong friends, do not equate to murder, nor does it allude to the admission of guilt. Conflict is a byproduct of collaboration, not a prelude to murder. In R. and Galbraith, the court held that if the evidence is such that no reasonable jury could convict, the judge must withdraw the case. That threshold was clearly crossed here. The Antigua and Barbuda Criminal Procedure Act Chapter 117, Section 35, where at the close of the charge, it appears to the judge that a case is not made out, he shall direct the jury to return a verdict of not guilty. My ladies, my lords, this argues that the judge must withdraw the case if the evidence, as in this case, a fingerprint on a plaque, or an unrelated item, or a vague argument, is too weak to support a conviction beyond reasonable doubt. In Tepper and R, similarly, the court declared that circumstantial evidence must exclude every reasonable hypothesis other than guilt. Here, reasonable alternatives abound. Another person could have entered. The scene was unsecure. He was popular. There was no direct link, no confession, no surveillance, no DNA.
Miss Daniel, I hate to interrupt you, but Nosy Nancy knows Vibes Skillis' voice very well. She listens to his music. She's seen him being interviewed. So you don't think that has strength in it, that she is sure it was him she heard?
Respectfully, no. I do think that recording music and recording a song is different from how I may sound in my everyday life, even when shouting. So no, I don't think so. My ladies, my lords, suspicion and speculation, no matter how dramatic, cannot be a cornerstone of a criminal conviction, not this criminal conviction. This case crumbles under the weight of its own insufficiencies, and as such, we respectfully ask that the court quash this conviction and enter a verdict of acquittal. I hand over to my co-counsel.
Just before you hand over, if it is that Sandra's evidence was rejected by the court, for some reason it was not tendered and it was not admitted, would your position on the sufficiency of the circumstantial evidence change?
No, it
Why
would
is
not,
that?
respectfully.
What would be your position? Tell me about it.
I think that we don't have an uncorroborative admission here. When we talk about a witness, we talk about which sense they use. Also, we have the proximity of time, where Sandra Harris claims that she saw the appellant driving towards Mr. Blizzard's house close to 8 p.m. The appellant mentioned that he left at 6 p.m. And then we have Nosy Nancy saying that she overheard an argument at 8 p.m. Additionally, when the post-mortem exam was conducted on May 16th, we did not receive a time of death. And so this is questionable.
If I may follow up, I'm looking at the written submissions, the fact pattern here, and it says the report of neighbors hearing loud voices and sounds of an argument came from Blizzard's villa shortly after 8 p.m. So it's not accurate to say pinpointedly it was 8 p.m. My understanding is that it was after 8 p.m., which does that not square with the eyewitness's account that she saw someone who resembled Vibe Skilly driving towards Blizzard's villa around 8 p.m. And then the ear witness accounts are that these conversations, the utterances were made after 8 p.m. What say you to that? Doesn't that line up?
The time,
yes.
maybe yes, but then there are other factors that we have to consider in this case, like a downpour of rain.
Okay.
Even if you had known the appellant for 15 years, or you listened to his music regularly, in a downpour of rain and the proximity at which neighbors live, would you be able to hear the appellant speak?
I may very well have been. Depends on how close I was to the apartment in question or the unit in question.
But then don't you think that she would have had to been outside of her house?
Something to think about. Yes.
And just so I understand, voice identification, are you saying it is important or it is not important in this matter?
It is important. Yes.
Very well.
Yes. My co-counsel.
Thank you.
Thank you.
Thank you.
Good afternoon, everyone.
Good afternoon,
God
sir.
bless everyone here. All glory to God for allowing us to be here safely. And your lordship, just to add on to something you should think about also, is that if they were able to hear screaming or argument from his villa in that said rain, don't you think they would have heard the glass breaking, the tumbling, the screaming if he was being murdered, and things along that sort? There's something for you to also think about.
Very well, sir. Continue your submissions.
Yes. As my co-counsel said earlier, I will be discussing grounds 1 and 3, starting with ground 1, the unreliable identification evidence. Your lordships and your ladyships, this case begins with a single shaky assertion and ends with a shaky assertion. Sandra Harris claimed that she saw the accused in the act, but what she saw or thought that she saw is blurred by the rain, distorted by distance, and clouded by conditions no court should deem reliable. My co-counsel touched on that a bit, and you guys questioned her about that a bit. But just to add on to some things is that, yes, you may be familiar with someone X amount of years, but that doesn't excuse the fragile mind that a human has. How many times throughout our lives, throughout our friends' lives, or family members' lives, have we mistaken someone for them? And vice versa. Sometimes we think that we see that family member, but it's actually a stranger. And the reason is because of similar patterns. For example, I may see a man similar like you doing the same pose you're doing right now, and think that that may be you. But it doesn't necessarily mean that it is you, Your Honor, just to add on that.
Can I just make a point? Is it not possible that you could have known someone for 15 years and from a distance you've recognized them?
Yes, of course. That is very possible, Your Honor. Okay. But it's also possible to mistake them.
And do you not think that the time period in which that Sandra was able to observe vibes was sufficient?
No, I do not think 5 seconds is sufficient to identify someone, because you also have to take into consideration the factors, the dismal factors such as the rain, the speeding car, and you have to also remember that Miss Harris was also driving, so her eyes had to be on the road and on the man, or whoever that was, at the same time.
Would you think that the time period would differ for identification versus recognition?
What do you mean by that, Ms. Lordship?
The time period, 5 seconds, would that have been sufficient if I am just looking at you and trying to identify you, as opposed to I have known you for over 15 years and in less than 2 seconds I recognize that this is Chad?
No, the reason I disagree with you is because of what I said earlier. I may know you for X amount of years, but that doesn't mean that I am always going to accurately identify you 100% of the time, Your Honor. I might see someone who looks as beautiful as you on the road, but that doesn't mean that she is you. Do you understand what I'm saying, Your Honor?
Continue.
Yes.
But isn't it more likely that you'll be accurate if you know the person for, say, 15 years, as against having met them a month ago?
Yes, I'd say so.
Okay.
Very
well.
More likely, but not certain. Sandra Harris alleges that she identified Mr. Parker outside Blizzard's villa during a thunderous downpour, yet the visual circumstances were dismal, as I said earlier, limited lighting, pouring rain, and a substantial distance through a window, and let's not forget, she said that she saw the vehicle speeding. And there's also no corroboration or no other witness to support her version. Yes, you might think of Nosy Nancy, but as my co-counsel said earlier, the senses are different when we're dealing with corroboration. Just because you heard doesn't mean that you saw. So you can't use that as the same as a backup claim as you're a witness of seeing Mr. Parker. You could say you allegedly heard Mr. Parker, but that's in of itself a completely different corroboration. And you might also think, well, Nosy Nancy wasn't the only one, there was also the neighbors, but as I said earlier, if they were able to hear arguments, why weren't they able to hear screaming, pain, breaking of glass, window shattering, and things along that sort? In the case of R and Turnbull, the court stressed that identification under difficult conditions must be approached with the utmost caution, Your Honor. The Turnbull guidelines, they're not optimal, they're essential. And yet, the trial judge failed to properly instruct the jury on these very dangers, Your Honor. Furthermore, if you look in the case of Mills and the Queen, the Privy Council warned of the dangers of inherent but honest mistaken identification, Your Honor. And it's not academic, it is practical. Human memory, as I said earlier, it's fragile, Your Honor, especially when in situations like that. Sandra Harris had no prior opportunity for clear observation, and her identification was influenced by the chaos of the moment. There is no corroboration of Sandra Harris's sighting, no forensic evidence, no surveillance footage, and no DNA linking Mr. Parker to the scene at the time of the murder. The prosecution may argue that Sandra's long acquaintance with Mr. Parker makes her identification trustworthy. However, as I said before, recognition does not negate environmental limitations. Familiarity cannot be undermined by distance and poor visibility, especially in a moment of stress or fleeting that she was in. Remember, she was driving and there was a thunderous downpour, Your Honor. Please keep that in mind.
Just before you continue, the information here is that she saw him for 5 seconds.
Yes.
Had she seen him for 1 minute, would your position change?
I don't think you could just say 1 minute. You have to also talk about if in the 1 minute is it still raining? In the 1 minute is lightning still striking? Because you can't just say 1 minute like that, because just because the vehicle is tinted, it doesn't mean that you could see perfectly through it, because you still have to take into consideration the other factors, the speeding, the rain, and things along that sort. So it depends on the context that you have to phrase for me to answer that properly, Your Lordship.
Very well, continue.
Yes. Moreover, her testimony contradicts other elements. No physical ties to Mr. Parker to the scene at the exact time of the crime. No other neighbor corroborates her sighting, and crucially, no weapon or forensic link backs up her statement. Your Honor, justice demands more than a hopeful guess in horrible weather conditions. And this identification was built on perception and not proof, Your Honor.
Just before you continue, are you saying that in order for the jury to rely on Sandra's evidence, there has to be somebody else corroborating that they saw Vibes Skilly as well?
With accurate corroboration, yes.
And if that is not there, the jury cannot rely on what Sandra is saying?
No, Your Honor.
Very well.
If I may turn, Your Honor, to the law, Section 9 of the Evidence Act, Chapter 155, makes it clear that for evidence to be admissible, it must bear upon the probability or improbability of a fact in issue. Sandra Harris's identification made under the compromise conditions fails this standard. The statute reinforces our position that unreliable evidence cannot be the bias or basis of criminal conviction. Your Honor, you have to, your lordship and your ladyship, sorry, you have to also take into consideration this is a man's life we're talking about. How can we have a final verdict of guilty, a verdict that can ruin a man's life off of such dismal and unreliable conditions, Your Honor? I'll now be going to ground 3. Jury tampering and the right to a fair trial. Your lordships and your ladyships, perhaps the most chilling element of this case is not what happened outside the courtroom, but inside. When a juror is threatened and nothing is done, the trial itself becomes infected with injustice. And we know that the jury is one of the most, if not the most important aspect of deciding a verdict in a case. During trial, a juror reported being threatened, your ladyships and your lordships. The appropriate response would have been immediate to discharge the jury, investigate thoroughly, and safeguard the impartiality of the process. Yet the trial judge dismissed the concern and proceeded as though nothing had happened.
If I may, just to clarify,
Yes.
the words that were uttered to juror number 7, was that really truly enough to substantiate a threat?
That's a very good question, Your Honor. Now, in of itself, it may not be a threat, but the fact is, the young lady, Miss Shaky, she took it as a threat based on the evidence. And the evidence and the context is that she went to the registrar and reported the matter, Your Honor. If this was something that she thought wasn't related to the case, why would she even think about going to the registrar, think about reporting this, Your Honor? So we have to keep that in mind, that she, off of the context and the evidence, felt like this was a threat, and it tampered with her mind, Your Honor, your lordship and ladyship.
But you do agree that at no point it was said that the person did not say anything about the case to her?
Yes, I do agree with that.
And I do have a follow-up question to my brother and my sister. The judge in this case, while summing up the evidence, instructed the jury to stick to their oath and make their decision based on the evidence heard in court. Does not this, the fact that this occurred, wouldn't that suffice?
No.
And if not, what is your legal authority why this doesn't suffice?
Respectfully, I don't think it suffices, because the fact that it wasn't mentioned, it doesn't mean that she didn't think about that during her decision, your lordship. It doesn't mean that just because the judge said that, it doesn't necessarily mean that she is going to take that fully. We still have to understand we're not in a movie, your lordship. We're dealing with humans and how humans think and the fear of how humans act, your honor. May I continue?
And I did ask your authority for why this doesn't suffice.
Right. If you
Okay, continue.
If we look at some case laws, we would start with in R and Misra, 2004, the House of Lords emphasized that any suggestion of jury bias or coercion fundamentally undermines the legitimacy of a verdict. Justice must not only be impartial, it must appear to be impartial, Your Honor. I'm also going, if you will allow me, I'll also like to talk about another case law. Carlton, Bedminster, and the Queen. The Privy Council found that failure to address jury intimidation creates an unsafe conviction and undermines public confidence in the judicial process. And the impact here is severe. The jury was no longer free. The conscience was compromised, Your Honor. The foundation of the trial, it was shattered.
But in the instance where Ms. Shaky didn't tell any of her peers, how was it undermined? How was it compromised?
As I was saying here, the fact that if I go back to R and Misra and the cases, the judge has a responsibility to tell the jury, Your Honor. And it also says that the jury, they may not only be impartial, but they have to look impartial, Your Honor. How can we say with 100% fact, with a straight face, that this jury was done fairly? How can we say that this trial did not have jury tampering in it? How can we say that this trial had a fair jury when one of the jury showed through the evidence and the context that she felt threatened and the judge did nothing about it, Your Honor?
Is it fair to say the judge did nothing about it? The judge instructed them to stick to their oath and make their decision based on the evidence heard in court.
Okay, let me rephrase. The judge did not say anything about her being threatened.
Okay.
I'll also like to...
Just
question?
one follow-up. Are you suggesting that the judge should have specifically addressed the jury?
Yes.
All of them gathered on the panel about the fact that she was threatened?
Yes, Your Lordship. May I continue?
Very well.
I refer Your Honor to Section 48 of the Criminal Procedure Act, Chapter 117, which gives the court authority to discharge a jury where there is evidence of external influence or intimidation. The incident reported by juror number 7 raises serious questions about whether this jury can deliberate free from pressure as required by law, Your Honor. We must ask ourselves, how can a guilty verdict be trusted when the jury itself was under siege? Justice must not be fearful, Your Honor.
I just have a question for you, sir.
Yes, sir.
You
Yes,
feel that Cindy would have been unable to carry out her duties with integrity, fairly and impartially because of what was said to her?
I'm sorry,
I'm
Your
saying, do you
Lordship.
feel that Cindy would not have been able to carry out her duties with integrity and impartiality
because of
what was said to her?
Yes, Your Honor. Your
Okay.
Lordship.
And is it your position that the entire panel should have been discharged and not just that one juror? Noting that it indicates that the other jurors were not aware of the threat?
No, just Miss Shake.
I see.
Yes. Okay. We stand at the end of a trial that should have never begun in the first place, and before a conviction that cannot be allowed to stand. Throughout this case, we have laid bare 3 critical, fatal flaws in the prosecution's path to guilt, Your Ladyship and Your Lordships. Firstly, we exposed how Sandra Harris was allowed to define and decimate a man's future based on a fleeting glimpse in the middle of a storm, Your Honor. No corroboration, no clarity, only the illusion of certainty where none existed. As the Turnbull and Mills decisions warn us, mistaken identity has been the graveyard of many wrongful convictions. Secondly, we dismantled the prosecution's fragile web of circumstantial evidence. A fingerprint on an award, a loud argument between former friends, these are fragments of life, not proof of death. As Tepper and Gilbreth instruct, if the story could be told another way, if reasonable doubt exists, the law demands acquittal. And here, it doesn't just exist, it shouts. Third, finally, last but not least, this trial was marred by fear, not fairness. A juror sworn to impartiality, threatened and left unprotected. A judge sworn to justice, silent and unmoved. This is not merely procedural failure, it is constitutional erosion. In the words of Misra and Bedminster, a tainted jury leads to a tainted verdict. So I ask you, should a man be charged on gossip, on a jury gripped by fear, on guesswork? Adema Vibe Skilly Parker may have had a falling out with a friend, but personal conflict is not the standard. Proof beyond a reasonable doubt is. And that standard has not been met, and it's not even close.
Okay, I hate to interrupt. I'm just saying, when you look at the incidences individually, you're saying they're not enough. But if you look at them cumulatively altogether, you don't think they provide sufficient grounds for the conviction? Let me explain. I'm saying individually, the things you pointed out, like the identification, the rain, the speeding, then we have the argument in the House. Looked at individually, they may not amount to much, but I'm saying when you put them collectively, don't you think the prosecution have laid a solid foundation for the conviction?
Without proper context, yes, I would believe that. But if you genuinely look in and you dial in on the context of the entire situation, you look at the context of what Ms. Harris claims to have saw, the context of the evidence, the context of the juror situation, your ladyship, you would see that when you take in all of the context to add to all those points, you would see that it is really flawed. And this does not deserve a man's life to be put away over it.
Thank you.
We respectfully ask this court, this honorable court, to quash the conviction and return a verdict of acquittal.
Thank you, sir.
Thank you. Exactly. That's all writing. Yes, when you're ready, you may commence. Thank you.
Good afternoon.
Good afternoon.
May it please this honorable court, my name is Imaya Guinness and I am lead counsel on behalf of the respondent. Appearing with me this afternoon is co-counsel Cece Lewis.
Is
The
your name
appellants have-
spelt as in the
Drink.
beverage?
Guinness.
No, it's Geneess.
Very well, thank you.
The appellants have provided 3 grounds of appeal. The first one being whether the reliance on the identification evidence provided by Sandra Harris renders the conviction unsafe. The second ground of appeal refers to the prosecution's reliance on the circumstantial evidence and whether it was enough or substantial in grounding the conviction. The third ground of appeal refers to the judge's decision in not discharging the jury after the situation with juror number 7, Sydney Shaky. I will be making submissions on the first ground of appeal and co-counsel the third ground of appeal. The second ground of appeal will be split between lead and co-counsel. If it may please this honorable court, I would like to continue with my submissions.
Go ahead.
Thank you. The first ground of appeal states whether the reliance on the identification evidence of Sandra Harris renders the conviction unsafe. The respondents simply submit no, for 3 reasons. Firstly, Sandra Harris's identification evidence is in alignment with the Queen against Turnbull 1977 from the British Court of Appeal, which is applicable in our common law jurisdiction. Furthermore, in most recent times, the Eastern Caribbean Courts of Appeal have applied the Turnbull guidelines in our very own Carlton versus Bedminster 2010. When we look at the factors in Turnbull, they give a warning to the jury that an honest witness can make a mistaken identification. Furthermore, they outline guidelines when analyzing the quality of identification evidence, looking at factors such as lighting, distance, duration of observation. When we recall the conditions under which Sandra Harris made her identification, they are in perfect alignment with that of Turnbull. Sandra Harris identified the appellant in a well-lit area, no tint on the car, and she saw him for at least 5 seconds as he sped toward her in heavy rain. These conditions are aligning with that of Turnbull. She saw the appellant for at least 5 seconds. And furthermore, her identification is grounded in recognition. Therefore, it was admissible in the court. My second point brings us to, this is a case of recognition, which is stronger than identification by strangers. We look at the legal authority, Beckford versus the Queen, 1986. This states...
Just before you continue, there's no evidence here about an identification parade being done. Would you say an identification parade would have served a useful purpose here where Sandra would go and do a formal identification of Vibes Keeley before he was charged?
No, it would not be useful. Given the long-standing familiarity of 15 years between Sandra Harris and the appellant, the identification parade would be counterproductive as she would immediately recognize the individual that she knows.
Very well. Continue.
The second point, I must repeat, recognition is stronger than identification by strangers. And when we look at Beckford versus the Queen, 1986, they state that close friends and family members can provide an identification. However, mistakes can occur, but it is less likely to be in an error. Furthermore, the case with Justice of Appeal Campbell states that in cases of recognition where the accused is well known by the witness for an extended period, the true test might be that of credibility rather than an honest witness making a positive yet mistaken identification. The respondents are submitting that Sandra Harris is a credible witness, as she merely saw her friend driving towards Blizzard's residence. She did not know that he was going to commit a crime. It was only until the news broke on May 16th that she realized her sighting was crucial to this case, and therefore she made a prompt reporting to the police.
How would you,
I'll defer to my sister.
How would you respond to the appellant's position that 5 seconds during, as they describe it, thundered-like weather, heavy rain, and speeding, it's 5 seconds, how is that sufficient?
It is sufficient, once again, because it was outlined in the Queen Against Turnbull. This is a case that is applied globally when dealing with identification evidence. Furthermore, the conditions under which Sandra Harris made her identification. Yes, it was raining heavily at the time. However, Vibe Skilly was driving toward her. Furthermore, he was speeding toward her. And any responsible driver would be focusing on oncoming traffic and the traffic in front of them and behind, attaching equal weight of focus. So a black car speeding in heavy rain was bound to catch anyone's attention as to who could be driving like this at this time of the night in these weather conditions. And that was how she focused on the driver and was able to identify and recognize her longtime friend, Vibes Skilly. That is how I would respond.
Just a question.
My question was addressed by her.
Absolutely. You don't think 5 seconds is a fleeting glance?
I don't believe 5 seconds is a fleeting glance, especially given the long-standing familiarity of Sandra Harris and the appellant. Pardon me?
Sorry, go ahead.
Any one of us can identify our friend from 5 seconds, and it is more than substantial in grounding her identification.
So just so I understand, you're saying that you don't believe 5 seconds is a fleeting glance in this, based on the circumstances before us?
No, I do not. And furthermore, to bolster what I am saying, it is more than 5 seconds. This car was speeding toward her. Therefore, she had more than 5 seconds to see the car from at the end of the road. Furthermore, the distance is accounted for because this car had to pass Sandra Harris, accounting for proximity. The car had to come close to her vehicle. And with no tint, she was able to identify the appellant.
Come, counsel. You're saying it's more than 5 seconds? No, we're not there is no evidence in this case of the car specifically being recognized. Oh, that's the car that Vibe Skilly drives. We're talking about recognizing the identity of the person. You're saying that the facts in this case substantiate that she had more than 5 seconds? Because she saw the vehicle. It's one thing to see the vehicle coming, to have had sight or be monitoring the onset of the vehicle from prior to 5 seconds. But it's another thing for the vehicle to come within distance enough for you to isolate the individual driving the vehicle. So are you suggesting that in these circumstances she was able to recognize the accused person for more than 5 seconds? The opportunity for observation was more than 5 seconds?
No, my lord, I'm saying that she saw him for at least 5 seconds. The question was asked or presented by the appellant regarding her focus.
Okay.
And I, the respondent, are submitting that a speeding car in night, in heavy rain, was bound to catch any responsible driver's attention. So she may not have recognized the individual from far away, but she had at least 5 seconds to identify him, and given the familiarity, it was grounded.
I see.
May I continue with my submissions?
Continue.
Our third and final point regarding the identification evidence speaks to the independent corroboration occurring with the voice identification provided by Nosy Nancy. The facts show that Nosy Nancy is a dedicated, long-time follower of Mr. Vibe Skilly. She not only listens to his music, but follows his interviews where he is speaking. She also follows him on several social media platforms, so therefore, she is exposed to his voice and not by mere coincidence. It was intentional.
If I may. If I may. Earlier, my friend asked about the potential utility of an identification parade. Are you not aware that something akin to what is done, visual identification, can be done in the realm of ear witness identification? Say have multiple recordings of various individuals and get the person to identify or indicate why it is that they recognize this voice vis-a-vis that voice. Couldn't something of that nature, an ear witness parade, have been employed in this particular case? Would
No,
that have been useful?
No, my lord, I will reiterate my point. It would be counterproductive. The familiarity between Nosy Nancy and the voice of the appellant would be counterproductive because she knows his voice, and it is not something that just happened out of a situation. This is something, a build-up of frequent exposure to the appellant's voice.
And my follow-up question, my reading of the case law is that, or some of the case law, is that ear witness identification is particularly fraught with difficulties vis-a-vis or when juxtaposed with eyewitness identification. Do you agree with me that ear witness identification is inherently problematic when compared to eyewitness identification? Oftentimes, persons within one family may be mistaken in terms of the voice. What they think to be your brother is not your brother. Also, a person's voice in different contexts may sound different. A person may sound different over the phone vis-a-vis in person. So in light of these particular nuances affecting ear witness identification, is it exactly on all fours with eyewitness identification? Address me on that.
When compared to visual identification, yes, voice identification may have some discrepancies as such that you stated.
Yes.
However, that does not dispute that it is admissible in the court. And the circumstances surrounding the voice identification, the familiarity, and the mere fact that the appellant was bellowing through the people's neighborhood after 8 o'clock in the night, she was able to hear his voice. And when we look at cases such as Neville Barnes and Rohan Taylor that are grounded in voice identification, the familiarity was more than substantial in making it admissible in the court. So, with comparison to visual identification, I am saying that no, it does not carry the same weight. However, it is still admissible, or it can be used as evidence in the court.
And I want to be clear. Are you saying it doesn't carry the same weight? I just want to ensure that I'm understanding you correctly. Are you suggesting that it doesn't carry the same weight?
Yes, my lord.
Okay.
I would just like to ask a question following from that. You accept that Mr. Parker is a performer, and how he sings and how he may interview could be very different from how he may talk on a day-to-day basis with a friend? Are you familiar with the fact that sound engineers can make people's voice sound slightly different?
Yes, my lady. I agree that when someone sings or performs, their voice may sound different. However, Sandra, my apologies, Nosy Nancy, has had exposure to his voice under numerous circumstances, through his performances, his music itself, his interviews, and through exposure on the social media accounts. She has had a variety. Therefore, it would account for those circumstances of her possibly having a different idea of how the appellant's voice may sound in a different circumstance. Furthermore, the facts of the case do not suggest that this situation of his voice differing in different contexts are utilized.
And you think that's sufficient, even though she doesn't have any type of personal relationship with him?
Yes, my lady,
Thank
due
you.
to the familiarity.
Thank you.
May I continue?
Yes, continue, please.
Bearing all of this in mind, Nosy Nancy's voice identification corroborates Sandra Harris's sighting. Sandra Harris recognized the appellant driving towards the Blizzard's residence at around 8 p.m. Then, after 8 p.m., not only Nosy Nancy but other neighbors heard the voice of the appellant shouting after 8 p.m. Thus, these two bits of evidence corroborate each other, grounding the appellant to the Blizzard's residence around the time after he said he left.
I just have a disquiet that I have to address. Are you saying neighbors other than Nosy Nancy provided ear witness identification in this case?
The facts of the case state that neighbors heard the confrontation happening after 8 p.m. However, Nosy Nancy, who is familiar with the voice of the appellant, was utilized with her voice identification.
Okay, just wanted to make that clear, that fact.
Yes, my lord. I will now move on to the second round of appeal, which states whether the prosecution's reliance on the circumstantial evidence was substantial in grounding the conviction. Firstly,
Before you continue, is it permissible for us to rely on circumstantial evidence?
yes, it is, my lord.
Where does that come from?
We can utilize the case. I crave your indulgence. When we look at Blackstone's criminal practice and the case Galbraith versus R, circumstantial evidence was utilized in those cases. Thus, it is admissible.
You refer to cases, but I hear you citing Blackstone and Galbraith. Which other case are you referring to? Or
I'm
are you
referring
saying
to
instances?
Oh, my apologies. I'm referring to Galbraith.
Okay, continue. Just wanted to
Blackstone's criminal practice, 1998, defines circumstantial evidence as the evidence of relevant facts, facts from which the existence or non-existence of facts in issue may be inferred.
Can I just, sorry to interrupt, this is bothering me too. Everybody sees a car driving towards Blizzard's house. The neighbors hear noise, but I don't see that anybody's saying they actually saw the car there. They heard noise because only Nancy is saying, I recognize the voice. Do you think that's not a problem?
No, it is not a problem.
Okay.
Should I elaborate?
Please.
Ms. Harris provided visual identification of the appellant, while Nosy Nancy provided voice identification of the appellant. Although the neighbors have not seen the car of the appellant, that does not dispute the fact that he was there. And there's several sources that point that Mr. Adima Vibes Skilly Parker was at the Blizzard residence on May 15th at around 8 p.m.
He was seen driving towards. He could have been going anywhere. He might have gone to his girlfriend's house. That's not possible?
Possibly. Okay. However, it could also be inferred that he was driving towards the Blizzard's residence.
And why is that?
Because Nosy Nancy heard the voice of the appellant. Also, the fact that there are more than one source pointing that Mr. Vibes Skilly Parker was at the Blizzard's residence at a stated time. These circumstances are not standing on their own. There's more than one bits of evidence that point that he was there.
Very well, you can proceed.
As stated, Blackstone's criminal practice 1998 states circumstantial evidence is the evidence of relevant facts, facts from which the existence or non-existence of facts in issue may be inferred. Circumstantial evidence is also often referred to as a cord. We have 4 strands to our cord of circumstantial evidence, the first one being the voice identification provided by Nosy Nancy, the second being the lie told by the appellant regarding when he left the Blizzard's residence, the third being the motive, and the fourth, the fingerprints found on the murder weapon. I spoke earlier about the voice identification evidence regarding Nosy Nancy. However, when we look at cases such as Rohan Taylor, they're grounded in voice ID. And furthermore, The Justice of Appeal states, in order for the evidence of a witness that he recognized an accused by his voice to be accepted as cognate, there must be, we think, evidence to the degree of familiarity, which I elaborated on earlier, the dedicated following of Nosy Nancy, the exposure, the variety of exposure that she has to his voice. Furthermore, he states, the occasion when recognition of the voice occurs must be such that with sufficient used words as to make a recognition. Neville Barnes versus R reiterates this point, saying that the greater the familiarity of the accused, the less words need be spoken. So when Mr. Parker was shouting, "You're nothing without me," those 4 words were more than substantial in grounding the voice identification provided by Nosy Nancy, because immediately she recognized his voice.
And counsel, when the counsel for the appellant made mention of the weather conditions with regards to hearing Mr. Parker, what do you have to say in response to that? And why did they not also hear, as they raised, glass breaking and all these other things happening?
The weather conditions under which took place was heavy rain. And the reason why Nosy Nancy and other neighbors were able to identify that there was shouting taking place was because the appellant, as well as the deceased, were shouting. Glass breaking and furniture being thrown over is not projected throughout the neighborhood as a voice that is intended to be loud. That is why we can rely on the voice identification of Nosy Nancy, because of the mere fact that the appellant, in asserting his dominance in the situation, shouted, "You're nothing without me."
What informs this notion about voice intending to be loud? Are you saying that the person in this instance was aiming to project their voice in an effort to be heard? What is this about intending to be loud? I want.
The respondents are submitting that the facts of the case state that there was a confrontation.
Yes.
And they were shouting.
Yes.
So therefore, in effort of that confrontation and the shouting, that is what propelled the voices to the neighbors.
Okay. I hear you. Continue.
Our second strand of circumstantial evidence is the lie told by the appellant regarding the time that he left the Blizzard's residence. The appellant stated he left the Blizzard's residence at 6 p.m. However, Sandra Harris, his longtime friend and Nosy Nancy, a frequent follower, placed the appellant at the Blizzard's residence after or at around 8 p.m. that night. When we look at the Queen against Lucas, they state, a lie can only be told in an inference of guilt if it is a deliberate untruth, relates to a significant issue or material issue, and is not told for reasons such as shame or fear. Furthermore, Lord Lane C.J. presented guidelines under which the jury should consider when dealing with the case. To be capable of amounting to corroboration, a lie told out of the court must be deliberate. It must relate to a material issue, and the motive for the lie must be out of a realization of guilt and or fear of the truth. Fourthly, evidence must occur to show that it is accurate. It was deliberate that the appellant lied about the time he left the Blizzard's residence. Why did Mr. Parker not say he left at 8, but he said he left at 6? Relating to a material issue, the time he left the Blizzard's residence is crucial in grounding him there, as he was the only person who had last seen him alive. Thirdly, this is out of a realization of guilt and fear of the truth hitting light. This man, who is a successful performer, is now being branded with murder. Fourthly, the evidence. Sandra Harris and Nosy Nancy provide corroboration for this lie. I made an error. Sandra Harris and Nosy Nancy's corroboration provide evidence which bolsters the accuracy of this lie. Co-counsel now will take over on the third and fourth point of our circumstantial evidence and present and make submissions on the third ground of appeal. Thank you.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
May it please this honorable court, my name is CC Lewis, co-counsel for the respondent. As previously mentioned by my co-counsel, Ms. Guinness, I will be presenting on the second half of issue 2 and issue 3, which centers on whether the circumstantial evidence is enough to ground a conviction and whether the trial judge was correct in his decision by not discharging the jury. If it may please this honorable court, I'd like to continue with my submission.
Go ahead.
The circumstantial evidence against the appellant, Adema Vibe Skilly Parker, is both overwhelming and sufficient in support of the jury's verdict of guilt beyond a reasonable doubt. As previously mentioned by my co-counsel, the prosecution contends that the combination of eyewitness testimony, the appellant's lies, motive, opportunity, and forensic evidence establishes that the appellant killed the deceased, Jerome Blizzard Thompson. Blackstone's criminal practice 1998 states that in the prosecution of murder, animosity between the accused and the deceased not only expresses a malicious mind, but also serves as evidence to the fact that the accused committed the crime. The evidence demonstrates that the relationship between Vibe Skilly and Blizzard was significantly deteriorating due to ongoing disputes on financial compensation and recognition. Blizzard, who played a key role in music production, reportedly felt overshadowed and exploited within the partnership, believing he was not being fairly credited for their success. Meanwhile, the appellant expresses frustration over what he perceives as Blizzard's increasing and unreasonable demands. Close friends and colleagues recall heated arguments between them, with some suggesting that the duo was on the verge of dissolving their partnership. These tensions create a volatile atmosphere that sets stage for violence. On the night of the murder, a credible witness, Nosy Nancy, testifies that she heard a heated argument between the appellant and the deceased. Blizzard, who was overheard shouting, and I quote, "You can't control me, and you'll never get away with this," to which the appellant responded, "You're nothing without me." This statement is particularly damning, as it's not only suggesting an intention to dominate, but also demonstrates an underlying resentment strong enough to escalate into violence. The fact that it was uttered during the final moments before Blizzard was last heard alive supports the prosecution's case that the argument culminated into murder. The appellant has a known history for wearied patience, particularly when dealing with the matters of control and recognition within his partnership. This pattern of behavior aligns with the prosecution's argument that this frustration with Blizzard finally reached its breaking point on the night of May 15th of last year. On to the forensics. The forensic evidence further strengthens the prosecution's case and draws a clear line connecting the appellant to the murder.
Sorry to interrupt. You're saying the forensic evidence. I assume you're relying on the fingerprint evidence?
Yes, milady.
You think that's sufficient that Mr. Parker's fingerprint was on the plaque, which they probably both won?
Well, seen as though that the murder weapon, an award plaque, was discovered near the body, notably had on the appellant's fingerprints exclusively. While the defense contends that the appellant may have touched the plaque during an earlier visit to reconcile with his partner, it does not preclude the prosecution for relying on this crucial piece of evidence to establish that it was involved in the crime.
So I have a follow-up to that. I do follow you when he says it does not preclude. But let's look at the fact that we're talking about a plaque. We're not talking about a knife or a gun, where the very fact of handling it is cause for concern. Here it is, we're talking about a plaque. To borrow from counsel for the appellant, it's not unusual. One, this was jointly owned by both parties. It is not unusual for Vibe Skilly to have handled this particular item. But to say without more that the mere presence of his fingerprint is hard forensic evidence corroborating this charge, what say you to that? It's not that, say, blood was found on the item. We're just talking about fingerprints on a plaque, not a gun, not a knife. What say you?
Well, my lord, the fact pattern states that there was an indication of blunt head force trauma on the deceased,
Yes.
which was assumed that the award plaque was the murder weapon.
You said assumed, which was assumed to be the
it was used on the
Okay.
deceased. My
Okay.
apologies.
Okay.
The absence of other identifiable fingerprints on the weapon and the fact that I crave your indulgence, my apologies. Given the fact that the appellant's fingerprints were solely on the murder weapon and the lack of any other identifiable prints, the inference is compelling. The appellant not only had contact with the murder weapon, but did so in circumstances closely aligning with the commission of the offense. This forensic finding is directly incriminating and also supported by other pieces of circumstantial evidence that point the appellant at the scene of the crime. May I?
Continue.
Yes.
I'm just thinking.
May I continue?
Her brain is flipping over. So, you did preempt me, but the question did form and concretize. Are you saying the fact that only Vibes Skilly's prints were found on this object, the plaque, in itself grounds an inference? And how so?
Well, seeing as though there was no indication of a third party at the scene of the crime, it could have only been the appellant. All pieces of circumstantial evidence points towards him and no other third party.
Okay, continue.
The evidence clearly shows that Vibe Skilly had the motive, opportunity, and means to commit the crime. His hostility towards Blizzard, the forensic findings, and multiple witness accounts all point to his guilt beyond a reasonable doubt. Even without direct evidence, the facts align in a way that leaves no reasonable alternative explanation. With that established, I now turn to issue 3. The trial judge was correct in his decision by not discharging the jury.
Before you get there, again, the thought is concretized. Regarding your suggestion, am I hearing you correct? Are you suggesting that in a criminal case where there is no alternative explanation for how the deceased came to become deceased, that in itself, the prosecution has no further onus, in that it is for the defense to substantiate and make out a potential third-party suspect? That all the prosecution need do is put forward circumstantial evidence tending to suggest that, hey, this was the last person present, without more. And in the absence of any explanation or evidence of a third party, that in itself lends itself to hard evidence substantiating an inference of guilt. Is that what you're suggesting?
Well, my lord, I point back to the fact that this piece of forensic evidence is only a single piece in a whole puzzle, assisted by other pieces of evidence that all point the appellant to the scene of the crime with the eyewitness testimony, the voice recognition, the appellant's lies, and also, lastly, the the heated arguments between, the motive between the, the animosity between the appellant and the deceased, all put together point to one reasonable inference.
Okay, I hear you.
And just
Continue.
before you continue, what would you make of a situation where Blizzard, the police indicates that Blizzard had reported Sandra a day before the incident, reported to them that Sandra had threatened him? What would you make of that?
Well, my lord, that situation is highly hypothetical and speculative, so it doesn't really have much relevance to the current case.
So you make nothing of that. So the fact that Blizzard indicates that, I'm just saying, if there's evidence that Blizzard indicates that Sandra was threatening him a day before the incident, that has no significance to you.
I'm not quite understanding what you're trying to ask me, my lord.
Very well. You can move on.
Thank you. Moving on to issue 3, this court should find it in favor of the respondent for the reasons that the trial judge properly exercised his judicial discretion. The incident involving juror Sidney Shaky did not compromise trial fairness. And lastly, the judge's measured response was sufficient to uphold the integrity of the proceedings. In discharging a jury, it's in the response of alleged interference or tampering is not automatic, but rather a matter of judicial discretion, guided by the need to uphold the integrity and the continuity of the trial. This principle is well established in Campbell versus R, where the Privy Council held that a judge must carefully assess a situation before determining an appropriate response.
And if I can interrupt you there, based on what you just stated, in the present appeal, did the judge do anything, do any investigations in terms of this alleged interference or tampering?
The judge did not launch any investigation. The trial judge's choice by not launching a formal investigation into the statement is justified. The investigation may have introduced unnecessary speculation and cast undue suspicions, and by declining to pursue the matter further, the judge preserved the objectivity of the jury, avoiding inflaming the incident or unrightfully concluding that the ambiguous statement that was directed to juror Sidney Shaky, "Y'all, make sure you do the right thing," devoid of any clear connection to the trial and did not warrant disruption.
But those words were accompanied with, she interpreted it as a threat. And without even making any form of investigation, I'm not saying disclose to the other jury members, but doing some formal investigation into it to find out whether, should I discharge this particular juror?
Well, Sidney Shaky...
Did he really exercise his discretion properly?
To that I answer yes. Sidney Shaky reported the matter to the registrar, showing transparency with the matter. As we have no evidence that she wasn't swayed by the statement, is the same as we have no evidence that she was swayed by the incident. Again, I state that the statement was ambiguous and could have been interpreted in multiple different ways.
Can I just ask you a question? You think it's a mere coincidence that a stranger, should have come up to her in a menacing way to say, make sure you do the right thing? You don't think it's connected to her jury duties?
Well, seeing as though we don't have any indication, there was no real indication that it was. Again, I say that this statement was ambiguous. It had no indication, there's no connection with this statement and the trial and her duties as a juror. Also, if the trial judge was to discharge the jury based on this vague statement, it would have been an indication that any form of outside influence without evidence of prejudice can undermine the proceedings of a criminal trial.
Well, let me put it in a cultural context. If a man comes up to you in a threatening way and says, make sure you do the right thing, it would have to be in the context of what I'm doing. And she was a juror.
Yes, but the context of the situation was that she was leaving Costco Supermarket. The approach, I crave your indulgence. As I said before, the matter occurred after she was leaving Costco Supermarket in the parking lot. That situation, the atmosphere of the situation, the setting of the situation, all was ambiguous and had no indication of her being, indication to her duties as a juror.
But don't you think it would have been even more frightening to know that somebody knows where she does her shopping and could come up to her very surreptitiously and say, make sure you do the right thing? You don't think that would have been a cause for concern?
Not really, milady, seeing as though, again, as I repeat, it had no indication. There was no direct threat, financial inducement, or oppression. I draw a comparison to the case Campbell versus R, where the jury tampering was extreme. A fellow juror offered others $500,000 to influence their verdict. This was a direct and explicit act of bribery, which the Privy Council determined a material irregularity. Not only were there multiple jurors directly approached, but the influence was tied to a specific outcome, which clearly rendered the trial unsafe. The ruling clarified that a mere reminder of the jury's oath was insufficient in cases of severe tampering. Unlike Campbell versus R, where the jurors were directly approached with a bribe, Ms. Shaky merely heard a statement, an ambiguous statement at that. The statement could have been interpreted in many different ways, including a general encouragement to act ethically rather than an attempt to influence an outcome for a trial.
Ethically when doing her shopping?
You never know. He could have been telling her to
Buy
quit
the right
meat.
type of meat.
Quit meat. You never know what it could have been in times like these, especially in Antigua. People will walk up to you, tell you to make sure you do the right thing when it comes to party choices, when it comes to anything. People will put their opinions and views on things onto you. So, again, as I said before, this ambiguous statement leaves no marking on the trial.
Thank you.
I must commend you, Ms. Lewis, is it?
Yes,
Ms. Lewis?
ma'am.
Yes, Ms. Lewis.
Yes,
And
sir.
you preempted my question with how ably you distinguished the case of Campbell versus R. I really like how you proceed to use an adage. You handled the actual minutiae of the facts and you applied it to the instant case. I like that. Thank you for that. That assists the court greatly.
To quickly wrap up, in conclusion, the accumulation of circumstantial evidence, strong motive, forensic evidence, voice identification, and eyewitness testimony leaves no reasonable doubt that the appellant committed the crime. This honorable court should uphold the decision of the trial judge. Since there was no real risk of prejudice, either conscious or unconscious, the trial was conducted fairly, and no miscarriage of justice occurred. Therefore, the respondents respectfully submit that the appeal should be dismissed. May it please this honorable court.
Thank you.
Thank you.
Thank you very much. Yes, yes.
Yes, 10 is fine.
All right, everyone. Our judges will take a 10-minute break.
I'll take my
And then
papers
we
with
will
me.
proceed to the third round this afternoon. All rise. This court stands adjourned for 10 minutes.
Start. Yeah, your mic. Your mic.
Could you introduce where you're from and your names, please?
Yes. Good afternoon, my lords and my ladies, and everyone else. I am Joelle Crump, as well as this is Kimani Edwards, and we're from Antigua.
Okay. What? Okay.
What's the name?
109 for the appellant.
Yeah. Oh, no, okay.
109.
I'm sorry, can you please repeat your name?
Pardon me?
Can you please repeat your name?
Joelle Crump.
Did you say Crump?
Joelle Crump.
Crump, okay. This is for the appellant.
Yes.
Joel as in the prophet?
No.
Joel.
No, Joelle.
Joel as in
Yes.
The jewel.
making
Joel.
up his jewels, okay? Joel Crump, team 109. And your co-counsel, what's his name?
Kimani Edwards.
Kimani Edwards. And the other team is team what number? 110.
Okay, when you're ready.
Good afternoon, my lords and my ladies. I am lead counsel Joelle Crump, assisted by my co-counsel Kimani Edwards, and we are the defendant for the appellant. Our client, Adima Skilly Parker, was wrongly convicted of murdering his best friend of over 15 years, Mr. Jerome Blizzard Thompson. The prosecution's argument stands on grounds of jury tampering, insufficient circumstantial evidence, as well as an unreliable eyewitness report. I will be explaining on the jury tampering, as well as the circumstantial evidence, while my co-counsel will continue on circumstantial evidence and move on to eyewitness report. The integrity of the jury system is the cornerstone for justice in our society. Judges are expected to ensure that defendants receive a fair trial free from influence and intimidation. In my client's case, juror number 7, Ms. Cindy Shaky, was intimidated outside of Crossroads Supermarket by a civilian who urged her to make the right decision. Although the prosecution may argue that the civilian did not specify make the right decision on what, it is important to note how Ms. Cindy Shaky took this intimidation. She took it as a threat towards the case. And we know this because she reported the incident to the registrar, who went to the trial judge.
Can I just ask, even though she took it as a threat, were the words in and of itself can it be really considered a threat?
Yes, my lady, it can be
explain?
considered a threat because the civilian told her, "Gal, make sure you make the right decision." She is a juror on a trial, and the juror's job is to make a decision on to whether the facts of the case proceed the defendant as innocent or guilty.
Shouldn't it be followed by or else?
My lady, could you repeat the question, please?
Yeah, make sure you do the right thing. Shouldn't it be followed by or else? Because the statement in and of itself doesn't really appear to be a threat, although she perceived it as one. Could it really be a threat?
Yes, my lady, it could be a threat because urging someone to make the right decision can be seen as threatening, as we see in cases such as Porter versus McGill.
What case is that?
Porter versus McGill, 2002.
Porter versus?
McGill. Is that all, my lady?
You can continue.
Are you, in your submissions, going to touch on the circumstances of Porter versus McGill and as to why it's instructive?
Yes, my lord.
Very well.
Cindy Shaky was threatened. She was petrified. She was intimidated. The case fact states that she felt a chill. My lord, I would like to tell you, if you are intimidated and you are expected to make a decision, it is not fair to my client that Miss Cindy Shaky can go forward and make a decision on his behalf concerning his life when she is intimidated and fearful.
If I may, I'm going to ask the question at this juncture. Could it not be said that this statement, make sure you do the right thing, is but a crude vernacular effort to impress upon the juror in question the importance of doing what she was sworn to do, which is to make a decision having considered all the evidence and to not have any ulterior purpose or consideration other than the evidence in this case. Isn't that the right thing for a juror to do in a case?
Yes, my lord, that is the right thing for a juror to do, but a juror cannot do that if they are intimidated. Is that all, my lord?
Continue.
Thank you, my lord. Ms. Cindy Shaky, in going to the register, who reported the incident to the trial judge, followed proper procedure. We know this in case, as I've mentioned before, Porter versus McGill, as well as Crown versus Smith, which says that the judge, if the judge is informed of an incident of intimidation, they are obligated to make the proper judicial procedures, whether it is to dismiss that juror or to hold a retrial.
Can you repeat that case for me, please?
The case is Porter versus McGill, and the other case is Crown versus Smith.
Crown?
Crown versus Smith.
Continue.
Is that all, my lady? Thank you. In Cindy's shaky intimidation and her being allowed to go forward and make a decision on my client's case, it is extremely unfair to my client. It jeopardizes future cases and it undermines the impartiality of the jury system. If a juror can go forth after being threatened and reporting the incident to the judge, and they can be allowed to go forward and make a conviction and make a decision towards a conviction, it is extremely irresponsible and dangerous. Evidence is deemed to be circumstantial when it leaves room for reasonable doubt. In the case of J. Mary Chain versus the Crown, which states, if there is an innocent alternative explanation, then the judge is obligated to encourage the jury to consider this alternative explanation. My ladies and my lords, I would like to present to you the insufficient circumstantial evidence that the prosecution has brought forth against my client. The prosecution brings forth fingerprints on an award plaque. My lords and my ladies, they did not specify when these fingerprints were left on the award plaque, whether it was a day before, a year before, a month before. It's also important to note that Mr. Blizzard and my client were music partners, they were business partners, and they most likely received the plaque together. Therefore, his fingerprints would have been left on the plaque in that instance. My client says that he picked up the award plaque while he was reminiscing on good times with his friends. I would also like to make the court know, allow the court to realize that my client and Mr. Blizzard were best friends for over 15 years. My lords and my ladies, you do not murder your best friend over financial matters. And I would also like to inform you that my client is a world-renowned musician, and he has some funds.
Says who, Ms. Crump, you do not murder your best friend over financial matters? What grounds that assertion?
My lord, I am saying this from the perspective of a regular person. Going forward and murdering your best friend is a bit of an extreme, my lord.
But Ms. Crump, you will agree with me that almost monthly on this God's green earth, wives are accused of murdering their husbands and husbands accused of murdering their wives over money. And I mean, the adage says that a wife, if not the best friend, is one of your closest friends, if not the best. And a person over the age of 15 recognizes that routinely persons are accused and convicted, and some of those convictions stand the test of time, of murdering father, mother, child. So this assertion, best friends don't murder, you don't murder your best friend over money. Elaborate, what grounds that?
My lord, I would like for you to consider the circumstances that are involved in those cases and the circumstances that are involved in my client's case. In my client's case, there was a dispute over financial matters. This is the only dispute that the prosecution brought forward to support their evidence. I'm saying that in other trials, perhaps there is another reason other than the financial matters that would lead somebody to murder.
So there has to be other reasons other than finances?
No, my lord, it does not have to be other reasons, but I'm saying that it is unlikely.
Okay.
Can I just add, have you not heard it be said that money is the root of all evil?
Pardon me, my lady?
Have you not heard it being said that money is the root of all evil? And as my learned colleague has said, when it comes to money, relationships really don't count. Money is a very motivating factor.
May I crave the court's indulgence, please?
Certainly.
Thank you, my ladies.
Thank you.
My client, Mr. Antigua Skilly Parker, as a world-renowned musician, has been in the industry for over 15 years and has sufficient funds to allow his business partner to get some more money if he requires it. As well as my client, as Mr. Blizzard was also in the industry for over 15 years and he has money as well. So it's not a case where the two parties have no money and they're arguing over squabbles of coins. They have money to accommodate each other. Does this answer your question, my lady?
You continue, my dear.
Thank you, my
Continue,
lady.
sir.
My client's fingerprints being on the award plaque does not make him a murderer.
There you go.
His fingerprints were left on the award plaque after reminiscing on good times with his friend, his best friend of over 15 years. They had fondness for each other. They knew each other since they went to high school together. My lords and my ladies, I would like to inform you that the award plaque is only believed to be the murder weapon. The prosecution did not state that this was the guaranteed murder weapon. The prosecution's lack of evidence also transforms into, they didn't mention any blood left on this award plaque. They didn't mention when the fingerprints were left on this award plaque. They didn't mention the size or the material of this award plaque. My lords and my ladies, I present to you an award plaque. This is a small plastic award plaque. This award plaque cannot be used to murder someone. It is not capable of promoting enough force to submit enough damage to kill someone. My lords and my ladies.
Sorry, are you suggesting that the plaque that was used was a similar size to that?
My lady, I am stating that the prosecution did not specify what size or material the plaque was. Therefore, it could have been this size.
Thank you.
You're welcome, my lady. My lords and my ladies, my client did not murder his friend. We know this because the trial that convicted him of murder was unsafe due to jury tampering, as well as the evidence that was presented before him was extremely circumstantial. It left room for reasonable doubt, as well as it was not specific onto the matters. My lords.
Before you continue, are you saying that the evidence, the circumstantial evidence that is present, points to more than one conclusion?
Yes, my lord. In terms of the fingerprints, although the prosecution claims that they were left on the award plaque when my client allegedly murdered his best friend, there's an innocent ulterior explanation where he left the fingerprints on the award plaque when reminiscing on good times with his friend. Is that all, my lord?
Very well, proceed.
Thank you, my lord. My lord and my ladies, the prosecution did not bring forward any evidence of blood. They did not bring forward any evidence that the fingerprints were left on the award plaque during a murder. They did not indicate any specific size or material that the award plaque was. For all we know, the award plaque was not even the murder weapon at all. It is only believed to be such. The award plaque that I present before you is small and insufficient enough to convict enough force to murder someone. Thank you, my lord and my ladies. I now yield the floor to my co-counsel, Kimani.
May it please this honorable court, I'm grateful for this opportunity to rise above you all, my lord and my ladies. As my lead counsel stated, I'm Kimani Edwards, the co-counsel for the appellant. I rise today to submit the conviction of my client, Adeem Parker, also known as Vibe Skilly, is out to be seen to be unsafe and out to be quashed. This case hinges entirely on unreliable identification evidence and weak circumstantial testimony, neither of which meets the high point of proof beyond reasonable doubt. My Lord, I will address two main issues: the insufficiency of circumstantial evidence relied upon the prosecution, and secondly, the unreliability of the identification evidence provided by Sandra Harris. My Lord, before I begin, I must state that Sandra Harris' identification can also be seen as circumstantial evidence also, but later on, I will show you and explain why is that so. Now, my Lord, the core issue is whether Nosy Nancy's circumstantial, where she stated that it's about the voice identification, my Lord. We must understand that is it even sufficient enough, compelling, and free of reasonable doubt to establish the appellant's guilt. My Lord, Nosy Nancy stated that, "You're nothing without me. You can't control me." And she also stated that she believed that Vibes Carter stated, "You're nothing without me." Now, my Lord, on the legal principles as seen in J. Mary Chain versus the King, highlights that circumstantial must be compelling, that it leaves no reasonable doubt. On the court, such as Byers versus the King, Crown versus Turner, and Crown versus Cairn, shows that whether it may be visual or even voice, it must be treated with extreme caution, which can weigh on factors such as opportunity, clarity, and consistency, my lords. My Lord, let's take a pause and talk about the opportunity. My Lord, Nosy Nancy, as stated in the facts, she said that she's a die-hard fan of Vibe Skilly. My Lord, if you hear someone you admire so much, won't you at least go outside to see if it's really him?
Maybe because it was raining she didn't, but she knows him extremely well. She listens to his interviews, she knows his songs, so she's very confident that it was his voice.
Well, my lady, I will talk about that later on, but I must answer you right away. Doing voices to songs and interviews can be alternated with technology, such as autotune, my Lord, and not even, my lady, not only that, but background music, like, for example, the instrumental behind of it, can alter the person's voice. But we must understand, my Lord, my lordships, that compared to, like, for example, emotional stress, we must understand that Vibe Skilly was under so much, like, anger to raise his voice. She's not a familiar person that talks to him every day, or not even, like, for example, see him every day, my lordships. So you must understand that she cannot know how he sounds when he's angry or when he's like talking normally, unless she's Vibe Skilly partner. And the answer to that is no, my lady. No, my lady, we must understand, for example, the environmental factors around it. The facts didn't state that where was the distance between Nosy Nancy and Blizzard House. So we must wonder, okay, is really Nosy Nancy down the road from Blizzard, or is she right next door to Blizzard House? The facts didn't state that, my lordships. So we must question, did she really hear the argument? Now, my lord, factors such as the TV playing from the other neighbor houses, or even dogs barking, or even cars passing can interrupt this, my lord, and listening to this. Now, the two phrases she stated, my lady, and my lords, we must question, why if you say that you listen to this argument, why is only two phrases you can present to the court? You can't control me and you're nothing without me.
But what would be the situation if she had heard 10 words?
Repeat that, my lord.
Had she heard 10 words, would that be any different? Would that change your position?
My lord, 10 words is like less than two phrases, if I'm correct.
So what you're saying is that the Crown is not able to rely on if it is that she heard 10 words, the Crown would not be able to rely on that for voice identification despite the familiarity of her to his voice. The Crown would not be able to rely on that.
Well, my lord, I will answer this like how she stated that she believed. How can you believe? Aren't you certain that you heard your so-called favorite artist? Aren't you certain about this? And not only that, she only stated 2 phrases. How can we just depend on just 2 phrases? It can be, for example, if I overheard an argument, I will be surely enough to state more than 1 phrase, or more than 2 phrases, more than 3 phrases if I overheard the argument, my lord. And especially if she named... Repeat that, my lord.
Authority for that position?
Well, no, my lord. But in a human form, especially in the facts, it says that she's a nosy Nancy, which means that she's nosy. And as a nosy Nancy, you tend to be very nosy and listen to what is going on around the community. So you're supposed to be establishing that you can list out more than 1 phrases from this argument if you're so-called right next door. Is that all, my lord?
Just to follow up with my friend, he uses the word authority. I just want to make it abundantly clear that I'm understanding. You're saying you have no case law on the point of this ear witness identification that supports your assertion. It's purely in the realm of logic that you're arguing from?
Well, my lord, I had stated a case earlier that circumstantial evidence from the Crown Turner versus Turner and the Crown versus Cairn must mean that evidence from either hearing or seeing must be valued that it must be seen that she can either have more sufficient evidence to provide for the court, and for that, on the scrutiny, on the carefully examine what she stated, is not sufficient enough, my lord.
And that is despite the fact that she's familiar with his voice from hearing it in interviews and songs.
Well, my lord, as I stated earlier again, it shows that although she's like a die-hard fan of Vibe Skilly, we must understand that attitude can play and so forth can play in these factors that he so-called know that you're a part of his music, my lord. Not only that, he's under emotional stress. He's angry. How can you recognize someone when they're angry? Unless you're their partner. Is that all, my lord?
Proceed.
No, my lord, she did not report any struggle of altercation in the house. So it really questions, did she really overhear the argument she couldn't hear any physical fight? Because, my lord, if you hear a physical fight, as the fact stated, furniture was overthrown, glasses were broken. So that means she could have overheard the fight. But she failed to mention that she recognized a physical altercation between them. So you really question, were you really there to overhear the argument? Were you even nearby to even hear the argument? All these questions, my lord, all these factors, we must understand that we cannot use Nosy Nancy as evidence to convict my client. Now, my lord, let's turn to Sandra Harris' identification. We must wonder if Sandra Harris' identification is reliable enough to support the conviction given it was made under several conditions, my lord. For example, the Crown versus Turnbull states that...
What?
The Crown versus Turnbull, I mean.
Turnbull?
Yes, my lord.
Okay.
Shows that the Turnbull requires that juries must be warned to exercise extreme caution considering factors such as lighting, distance, duration of observation, and the conditions under the identification occurred.
Are you saying that in this particular case, a Turnbull direction was not given? Because from my review of the facts, the learned trial judge did provide a Turnbull direction.
Well, my lord, the facts that I read didn't have any such things as that, my lord.
Okay. Carry on.
I pray for the court indulgence.
Carry on.
Thank you, my lord. Now, my lord, under Antigua and Barbuda Evidence Act, cases such as the King versus the Phillips, Taylor, reliability is mostly important, my lord. So, my lord, observation conditions. Let's talk about the rain that she stated. Is that solely enough to say that the lighting, heavily rain, darkness, although it stated that it was well lit, my lords, you must understand that inside the vehicle is dark. So how can you view someone in a dark vehicle?
There is no evidence in the facts that inside the vehicle was dark.
That's correct, my lord, but I would believe that my client is not so crazy to drive in a vehicle with light on inside.
But the
I
roads,
sometimes drive with my light on.
Well, to see the
Am I
road,
crazy?
to see the road, my lord.
but the area was well lit, so you could see outside.
Correct. But can you see inside a vehicle if it's dark inside, my lady?
But what does it say it's dark?
Well, if the area is well lit and the
The car is
vehicle's
dark.
window is not tinted, what prevents you from being able to see clearly into that
Because,
vehicle?
my lord, my lady, we must understand that the surroundings was nighttime. So although it may be well lit, it's still night. It's not like daytime when the place is, inside the car is bright because of the sun. Not only that, it was raining too. So now raindrops is on the windshield, raindrops is on the windows, which can also authenticate it not to view my client properly. See, he questions really. Now, I may argue, my lord, that the distance of how she observed my client. My lord, in the fact, it stated that she was driving towards her home, while she saw Vibe Skilly driving towards Blizzard House. And according to the fact, it said that they were neighbors. So in this means, my lord, all these factors, all these things, it means that she was driving directly behind of him towards the same area, my lord. Now, if it's that so, how can you recognize him just for 5 seconds from behind? My lord, I crave.
Where does it state that she was from behind, though? Where do you get this notion that she was from behind?
Because, my lord, she stated that she was driving towards her house, and she saw Vibe Skilly driving towards Blizzard's villa. And not only that, she's Blizzard's neighbor, which means that it's either that she's driving in front or behind. But, my lord, she said that she recognized my client for 5 seconds, which means that she's driving behind of him if you can recognize for someone for 5 seconds. Now, I will touch on how the time.
He was speeding. He was speeding, so maybe he was driving a bit faster than her.
That's correct, my lady. So how can you really recognize if someone is driving faster than you two? No, my lady, 5 seconds. Although you say that she was speeding, 5 seconds. If I may, can I turn my back towards you to prove something?
Go ahead. I'm intrigued.
My lord, can you recognize me while I face behind?
Yes.
Well, just my ear. Just my ear.
Well, you just turned around.
You're driving behind me, my lady. Can you recognize me if I'm face behind? Answer fairly, my lady. Can you recognize me? The answer is no.
But, if I may, would it be from behind or from a side profile?
Thank you, Chief.
It's impossible to do a side profile.
Well, if you're
Because she's driving towards her house, and it's also that she's Blizzard's neighbor, so which means that they drive in the same direction, meaning that they drive in the same path road.
But she wasn't speeding, but he was speeding. That's the point my colleague is making.
You can continue.
My lady, let's also consider another factor. Suppose you're driving in front, and I'm driving behind of you, and it's raining. Can you recognize me if I'm just looking in the mirror and just look down and continue driving for 5 seconds?
I can recognize your car, I think. I can go that far.
Correct. Sandra Harris did recognize the vehicle, but she did not say that what she really recognized. Like, for example, his shirt, what Julie was wearing. She didn't state any of those factors to recognize him properly. All she stated that she saw him driving a black vehicle, driving towards the victim house. How is that efficient enough? How is that efficient enough, my lords? That you're just saying you saw a black vehicle driving towards Blizzard's house, and you believe it was Vibe Skill. She did not say the license plate. She didn't say any type of vehicle it was. For example, Toyota, Ford, Honda.
But is the identifying and recognizing the vehicle, or is the issue recognizing the appellant?
That's a very good question, my lady, and I must answer it fairly. I'm trying to bring to the table, my lady, that all she stated that she recognized him driving a black vehicle. And the black vehicle did not specify that it was what type of vehicle, if it had any type of stickers on it. All she said that he was driving a black vehicle. There are so many black vehicles in Antigua and Barbuda. How can she just state that he was driving a black vehicle? Not only that, driving in rain, nighttime, although the place was well lit. And although the speed limit also, as my lady brought forward, how can we really trust that she recognized my client?
I hear you, Mr. Edwards, is it?
Correct.
I do know of persuasive authority arising from jurisdictions such as Canada, where when it comes on to the species of evidence that we're discussing presently, eyewitness evidence, it may be such that the sufficiency thereof is so deficient that it shouldn't even be left to the jury to consider. Correct. Are you here suggesting, and I want to understand, make sure I'm understanding you correctly, are you suggesting that the evidence in this case was so deficient that it should not turn both directions aside? It was so insufficient that it really ought not to be considered as eyewitness identification evidence. Is that what you're saying here?
Correct, my lord. And I will continue by saying this, my lord. 5 seconds, and you're his neighbor. If you're his neighbor, why won't you, like, when you finish, drive into your parking lot, in your house? Won't you at least recognize a little bit longer? Other than 5 seconds? Is that enough to say that you recognize someone while driving, or even if you stated that you parked up in a vehicle, in your house, came out your vehicle, and saw the vehicle inside of his yard? She don't state any of those things, my lords. So you must wonder, is she telling the truth that she recognized my client for 5 seconds? Is she telling the truth that she recognized a black vehicle? Because we may not know. She did not say what type of black vehicle. In the fact, he did not state that Vibes Killy owned a black vehicle. All he said is that he was driving a black vehicle towards her house. Now, my lord, there are certain procedures, such as the turnbull, where you're supposed to require to warn the juries. Also, this can be also seen in the Buyers versus the King. The judge failed to follow procedures, and the procedures is to warn the juries under such factors such as lighting, observation, duration of conditions, and so forth, my lordships. And the judge failed to just tell the jury all these factors can be seen in Sandra Harris, so we must not consider this evidence. So now, my lords, I leave you with this. The jury tampering, the unfairness of trial, nosy Nancy, circumstantial evidence, the fingerprint evidence, Sandra Harris identification evidence. It's like what the prosecution is trying to do is put up pillars to stand that to convict my client. But under these careful scrutiny, it collapsed. And so, my lordships, in the light of these significant flaws, in which my lead counsel and I clearly laid out, the appellant respectfully submits this conviction is unsafe, and we urge the court to quash this conviction and allow the appeal. I thank you.
Very well,
Thank
sir.
you. Yeah, when you're ready, you may start.
May it please this honorable court, I am Cameron Sincere, appearing alongside my esteemed co-counsel, Ms. Eloise Mitchell-Gooding, on behalf of the respondent in the matter Adima Vibeskili Parker versus the Crown. This case arises from the tragic and untimely death of Jerome Blizzard Thompson, a former childhood friend and longtime collaborator of the appellant Adima Vibeskili Parker. The facts presented before this court paints a clear picture of deteriorating relationship between the two, with disputes over financial compensation and artistic recognition, leading to irreparable tensions. On the morning of May 16, 2024, Mr. Thompson was found dead at his luxury villa in Jolly Harbor, the victim of blunt force trauma. The circumstances surrounding his death suggest a violent altercation, the conclusion of which was tragically his life. The appellant, Vibeskili, was convicted of orchestrating this erroneous crime. The respondent will prove that beyond a reasonable doubt, the conviction should stand, that the evidence supports the conviction of the appellant, not only through credible eyewitness testimonies, but through the solid circumstantial evidence. The issues to be determined in this appeal are as follows. Firstly, whether the identification evidence provided by Sandra Harris warrants the conviction unsafe. Secondly, whether the circumstantial evidence is sufficient enough to ground the conviction. And third and finally, whether the complaint made by juror number 7 warrants the quashing of the conviction. I will address the first two issues, while my learned co-counsel, Ms. Eloise Mitchell-Gooding, will address the third and final issue. Together, we will show that the conviction is both safe and just. With that, I submit to the court the case against the appellant, and I will demonstrate that the conviction be upheld in the interest of justice. I now turn to the first ground of appeal. The first issue before this court is whether the reliance on the identification provided by Sandra Harris, specifically her identification of the appellant, renders the conviction unsafe. The respondent submits that Sandra Harris's identification of the appellant is both reliable and credible, and we respectfully ask this honorable court to confirm that the conviction should stand based on the strength of her testimony. In addressing the reliability of identification evidence, the court is bound to consider established principles, most notably outlined in the case the Queen versus Turnbull, 1977 UK, which provides that the reliability of an identification depends on factors such as, first, the length of time the witness had to observe the suspect, secondly, the conditions in which the observation took place, and thirdly, the level of familiarity between the witness and the suspect. In this case, Sandra Harris is a long-time acquaintance of the appellant. She has known him for over 15 years. Not 3, not 2, not maybe 1.5, 15 years. A relationship which clearly strengthens her ability to make an accurate identification of him. The court should consider that the level of familiarity between the witness and the appellant goes beyond mere casual recognition, and the length of time Sandra has known him provides her with the opportunity to make an accurate identification.
Just before you continue, while there is no evidence here that an identification parade was done, would you say an identification parade would have served a useful purpose as it relates to Sandra identifying Vibeskili in the circumstances?
Yes, I would.
Explain.
My lord, may I ask, what do you specifically mean by parade, if I may?
You can just proceed.
Okay, thank you. The lighting conditions in the area were also favorable for Sandra to observe the appellant. Despite the heavy rain, Sandra noted that the roads were brightly lit, which meant that visibility was not obscured. In fact, Sandra's account makes clear that she was able to discern the identity of the driver due to the well-lit nature of the area.
But, sorry to interrupt, you don't think the heavy rain could have impacted or impaired her vision?
Yes, my lady, I do. But again, you have to take in consideration the length of time Sandra has known the appellant, 15 years.
And 5
and
seconds.
Also, the fact stated that Sandra accounts or claims that the area was well lit. Though the rain may have some impaired without the fact or without Sandra claiming that the area was well lit, then that may obscure her ability to see or recognize the appellant.
But when you add that extra factor of him speeding, doesn't that also impede her ability to recognize him in that 5 seconds? So you have the speed, you have the heavy downpour of rain.
No, my lady, I don't think so.
And can you just tell the court why?
15 years is a long time to know someone. My brother, my younger brother today, turned 15 years. And he was able, at 14 years, to recognize his mother in a crowd in a sports. Also, Sandra's claim is also substantiated by the additional circumstantial evidence.
But Mr. Sincere, that's your name?
Yes, Ms.
Very
Miller.
well. You will agree with me from the case law, and you have reviewed the binding authorities, cases like Turnbull, etc. Establish Beckford, and just from logic, notwithstanding the fact that you know someone 10, 15 years, 20 years, 30 years, there are times when, depending on the length of time one has to observe, one can reasonably and truthfully be mistaken.
Yes, my lord, I do
You agree with me on that?
But,
So you will agree with me on that?
yes.
So that being so, the length of time in and of itself is but one factor to be looked upon in terms of the overall assessment. And that assessment necessarily will rely on the length of time the particular observation occurred. For instance, I myself, having known my brother all my life, upwards of 40 years, have at times in a crowd, fleeting glance, had the first impression that, hey, there goes my brother. But when I go up to the person, it's a lookalike, it's not my brother. So the length of time that the particular or instant observation was looms into view as necessary to be examined. And when pieces that together with the fact that we're talking about heavy rain, you're driving, and you will agree with me that driving requires, you have to at some point in time be paying attention to where you're going. So when one takes that into consideration, does that not make this heavy insistence on the 15 years become less of a big deal?
To a certain extent, my lordship. But those aren't the only pieces of evidence that substantiate Sandra Harris's claim. For instance, the neighbors, specifically Nosy Nancy, who have claimed to have heard the appellant at the deceased villa shortly after 8 p.m. and Sandra Harris's identification said that she recognized the appellant heading toward observation aligns perfectly with other crucial pieces of evidence. As stated, Sandra saw the car heading towards the direction of the deceased villa at around 8 p.m. And reports from neighbors Specifically, Nosy Nancy reported hearing a voice she believed to be the appellant shouting, "You can't control me," the deceased shouting, "You can't control me. You'll never get away with this," followed by what is believed to be the appellant's voice replying, "You're nothing without me." This sequence of events, beginning with Sandra Harris's sighting of the car, followed by the neighbor testimony regarding the argument, reinforces the connection between the appellant and the scene of the crime. Given the aforementioned points, the long-term familiarity between Sandra and the appellant, the clear lighting conditions, and the corroborative testimony regarding the sequence of events, we submit that Sandra Harris's identification of the appellant is reliable and credible. We respectfully assert...
Sorry to interrupt you, but you would accept she just saw him driving towards the same direction. She doesn't know where he's going. He could have been going anywhere.
Sandra has known him for 15 years. She may not know exactly where he's going, but that is undermined, that speculative suggestion is undermined because she stated she saw him heading to the direction of the deceased villa. And followed by that, the other pieces of evidence, the neighbors, suggest that he indeed went to the deceased villa. It supports her claim.
What exactly from the other neighbors?
May you repeat?
What exactly from the other neighbors that supports Sandra's identification?
Hearing him, or hearing a voice that is believed to be his, shortly after 8 p.m. Now, Sandra said or claimed that she saw the car heading towards the direction of the deceased villa at 8 p.m.
Because he was going to his new girlfriend. How about that?
That is not...
The ear witness identification, the evidence of the voice ID. You have reviewed the authorities as it relates to ear witness identification or voice identification, and some of them instruct that voice identification is particularly difficult when we know about the Turnbull type scenario, how eyewitness identification, honest witnesses can be mistaken. It is even more particularly concerning when we deal with ear witness identification, considering the fact that oftentimes wives and husbands, vice versa, mistake the voice of their partner, because voice in different scenarios, while faces other than plastic surgery and with the passage of time, a face roughly remains the same. But voice, depending on the context, you hear me speak, you don't know how I sound when I sing, for instance. You don't know how I may necessarily sound when I'm angry or being histrionic. So these realities, which are particularly unique to voice identification, make voice identification particularly difficult to treat with. And the prospect of mistaken identity, voice identification increases. Would you agree with me? I've made a lot of statements, but would you agree with me that voice identification is even more concerning than even eyewitness identification?
I wouldn't necessarily say that.
Okay, they're on the same class. They're of the same class.
Yeah.
Okay.
But as we know, you can easily tell AI is prevalent now. You can tell by seeing someone.
Continue.
Specifically, Section 33 of the Evidence Act of Antigua and Barbuda allows the court to consider circumstantial evidence if it is relevant and tends to support the case against the accused. In this case, the physical signs of a struggle, such as the broken glass, the overturned furniture, and the evident signs of violence in the deceased villa, form part of a broader circumstantial case that points directly to the appellant's presence and involvement in the confrontation with Mr. Thompson. Furthermore, Section 35 of the said Act, the Evidence Act, Cap 10 of Antigua and Barbuda, emphasizes the admissibility of 8 p.m.
And what would you make of that? Assuming that he's telling a lie, what would you make of that?
I would make that he's trying to cover up his involvement in the death of Mr. Thompson, because why would you lie and say that you left 6 p.m. when you know you in fact did not?
And legally, can the Crown rely on such a lie?
I will say yes.
In what circumstances?
I beg your indulgence.
Mr. Sincere?
Yes.
I'm afraid I have to give you the opportunity to respond. I did look, and my sister did look, and I'm not seeing a section 33 of the Antigua Evidence Act. I'm looking at chapter 155, cap 155, and it stops at section 32. Are you referring to an amendment?
Yes, I am.
Okay, so could you advert to that? Tell me what specific amendment are you referring to?
I beg your indulgence.
Sorry to, but this is... We can come back to that, you know, if you don't have that reference.
Thank you, my lordship.
Yes.
Yes, I don't have it on me right now,
Very
but I
well.
will point out that we included this in a memorial
Very well.
and wasn't corrected, so we stand that.
All right. Continue, sir.
The sequence of events is critical as it places the appellant in the
Just
area
before you
shot.
continue, I was asking about lies,
sorry, my
the
lord.
circumstances in which the Crown could rely on the lies.
Sorry, my lordship. Yes, it could, in relying on the totality of the situation, keeping in fact or in mind the other crucial pieces of evidence that points to him being involved, then potentially lying about your presence and the time you left the villa can in fact substantiate the claim that he indeed committed the offense.
Very well, continue.
In addition, the appellant's own account of leaving the villa around 6 p.m. stands in direct contradiction to the testimony of Sandra Harris. The sequence of events is critical, as it places the appellant in the area shortly before the murder occurred. In addition, neighbors reported hearing a loud argument shortly after 8 p.m., which supports the notion that a violent confrontation between the appellant and the deceased occurred that night, potentially escalating into murder. The discovery of the murder weapon the following morning at approximately 6:30 a.m. corroborates the timeline. It is entirely plausible that the appellant, having returned to the villa in the late evening after his dispute with the deceased, engaged in a violent altercation which ultimately led to Mr. Thompson's death. The physical evidence found at the scene, the broken glass, overturned furniture, and signs of a struggle suggests that the confrontation indeed turned violent, supporting the theory that the appellant played a key role in its escalation. We also challenge the appellant's claim regarding his involvement with the award plaque. The appellant asserts that he was holding the plaque out of sentimental attachment. But this narrative lacks any independent substantiative claim or evidence to substantiate this claim. No credible testimony has been provided by the appellant to substantiate this claim. There is no proof as to when or how the appellant came in contact with the plaque, and a mere suggestion that it was for nostalgic reasons is speculative at best. In light of this, the respondent submits that it is unreasonable to accept the appellant's narrative of mere nostalgia. The presence of the appellant's fingerprint on the plaque casts significant doubt on the plausibility of the appellant's explanation. It is far more reasonable to infer that the appellant, in a fit of rage during the violent confrontation with the deceased, used the plaque to strike the fatal blow. In summary, the circumstantial evidence is both abundant and compelling. The sequence of events, the physical signs of a struggle, and the appellant's fingerprint on what is believed to be the murder weapon all point to the appellant's direct involvement in the death of Mr. Jerome Blizzard Thompson.
I have a question. My understanding of the law, Mr. Sincere, is that there is no onus on a defendant to proffer evidence to substantiate an alternative explanation that runs contrary-wise to the inference that the Crown seeks. Once it is plausible, that is enough. It is for the Crown to establish beyond a reasonable doubt that the only reasonable inference given the overall circumstantial matrix is the inference that you invite the court to reach. Am I correct?
Yes, my lordship.
Okay. So, that being so, and conceding that it is not for the defense to substantiate this inference, what say you as to why this inference is not reasonable given the overall circumstantial matrix?
Because, my lordship, all evidence points towards the appellant being there, all circumstantial evidence. There isn't any one evidence that is independent. All evidence are combined, and one must view this evidence in its entire totality, which points to the appellant being there and potentially involved in a murder.
Continue, Mr. Sincere.
We submit that the circumstantial evidence provides more than enough grounds for the conviction, and therefore the second ground of appeal should be dismissed. My co-counsel, Ms. Eloise Mitchell-Gooding, will now continue to demonstrate in her assessment of the inconsistent testimony and motive of the appellant that the circumstantial evidence is sufficient to ground the conviction. Unless the court has any other questions for me, these are the extent of my submissions.
Thank you, Mr. Sincere.
When you're ready.
Good afternoon, my lordships and my ladyships.
Good afternoon.
If it pleases the court, as indicated by my co-counsel, I, Miss Eloise Mitchell-Gooding, act for the respondent in the matter of Adima Vibes Skilly Parker versus the Crown. The respondent humbly stands before you today to address the appeal brought by the appellant, challenging his conviction for the murder of the deceased Jerome Blizzard Thompson. The respondent humbly submits that the trial judge's decisions were sound and therefore the appeal should be dismissed. I will address the key points raised by the appellant, focusing on the juror complaint, the inconsistent testimonies, and the established motive, to demonstrate the absolute integrity of the trial and the conviction. My lords, my ladies, firstly, I will continue addressing the second issue raised. That issue being whether the circumstantial evidence relied on by the prosecution was sufficient to ground the conviction. The appellant's statement that he left the deceased's villa at 6 p.m. with no account for his whereabouts at 8 p.m. directly challenges Sandra Harris's observation, which places him around the scene at 8 p.m. This discrepancy is not a minor detail. It strikes directly at the heart of his alibi. Sandra's long-term familiarity with the appellant and the bright lighting in the area render her identification both plausible and reliable. Therefore, this inconsistency cannot be ignored. The leading cases of the Queen versus F 2009 and the Queen versus B 2002 highlight the critical weight that inconsistent statements carry within legal proceedings. These landmark judgments firmly establish the principle that juries are not only permitted, but are indeed entitled to infer that a defendant is actively attempting to obscure the truth or a part of the truth when their testimony presented in court directly challenges established evidence. When significant discrepancies emerge, it raises a red flag, suggesting a deliberate effort to mislead the court. Section 36 of the Evidence Act, Cap 10 of Antigua and Barbuda, further supports this, allowing the prosecution at trial to challenge a statement's credibility through the highlighting of irregularities, be they internal contradictions, inconsistencies with other established facts, or oddities in the circumstances surrounding the statement's creation. The irregularity aforementioned calls into question the integrity of the appellant's version of events, suggesting that he may be attempting to cover up his involvement in the crime. This, coupled with the established motive of long-standing financial disputes and a tense relationship between the two, the jury had sufficient reason to question his version of events. It is not merely a matter of suspicion, my lords and my ladies, but it is a matter of logical inference based on the evidence presented. The appellant had both the opportunity and the motive to commit this crime. This illustrates an inescapable conclusion. Furthermore, we must emphasize the strength of the circumstantial evidence and the reliable identification by Sandra Harris. The appellant's presence at the deceased's villa, the physical evidence indicating a struggle.
Can I just insert interrupt? You
Yes, my
said
lady.
the motive. What is the motive? I'm not sure. What's the motive for the killing?
Sorry, my lady. The motive being longtime friends and persons acquainted with the two parties have stated that for a long time their relationship was becoming tense, their relationship was becoming more strained, and the appellant himself stated that at 6 p.m. they were having an argument. So what is to say that after this argument he was not heated and was not feeling, and as he left he was not feeling the urge to continue the argument and going back to the deceased residence and hence perhaps committing the crime.
Perhaps. Okay, thank you. Continue.
Thank you, my lady. Sandra Harris's identification, rooted in long-term familiarity with the appellant, adds a significant weight to the prosecution's case. These elements are not isolated. They converge to paint a clear and compelling picture of the appellant's guilt. The identification of a person known over a long period of time is extremely reliable and carries weight. To further support, one neighbor, Nosy Nancy, claimed to have heard the deceased shouting, "You can't control me, and you'll never get away with this," followed by a voice she believed to be the appellant replying, "You're nothing without me." With the knowledge of a long-standing dispute and a strained relationship between the two parties, it is not only fair but reasonable to assume that this statement would have been made by the appellant, especially since Nosy Nancy says she knows his voice because she listens to his music.
And before you continue,
Yes,
what
my
she
lord.
said legally, is that sufficient to establish the voice identification for the Crown to rely on it?
Yes, my lord.
Explain to me.
Could you repeat? My position would be to implore the importance of circumstantial evidence as opposed to simply relying on direct or statistical evidence. And to support this, the leading case of R versus Taylor, Weaver, and Donovan, 1928, asserts that circumstantial evidence can be as strong as statistical evidence, and sometimes even stronger depending on how all the facts align, my lord.
You're citing a 1928 case. Where does this case arise from? Refresh my memory.
Pardon me,
Where
my
does
lord?
this 1928 case arise from? What jurisdiction
The
and what
UK,
is
my
its
lord.
effect on this court? What ought to be its effect on this court? Is it binding? Is it persuasive?
My lord, it is binding.
Okay. What level UK case is this? House of Lords? Court of Appeal?
House of Lords.
Okay. Are you sure?
I'd like to believe so through my
Pardon?
research.
Pardon?
Sorry, I said I'd like to believe so
The
through
reason
my
why I
thorough
asked because
research.
your voice noticeably dipped. So that's why I'm
My
asking, are you
apologies.
sure? I'm not challenging you, I just want to know if you are sure.
Yes, my lord.
Very
My
well.
apologies.
Continue,
But
continue.
before you continue, I
Yes,
just
my
wanted to
lady.
follow up from my learned brother. Is there any authority that you may have on voice identification?
No, my lady.
Very well, continue.
A significant aspect of many DJs' identities lies in their signature DJ tags and vocal presence through their pieces, often intertwined with the producer tags that identify the tracks they've created, contributing to a recognizable and personal sound. Additionally,
I just need to intercept here. Are
Yes,
you
my
saying
lady.
because you know someone's voice from singing that you could never be mistaken about their voice?
my lady, the facts presented, the hypothetical brief, did not state that the appellant was a singer. They said he was a DJ and a producer.
Sorry, a reformer, sorry, you're right, he's an entertainer. So you're saying, because I think if we're talking about Mr. Parker, we're told that Nancy listens to his music, so I just assume maybe,
Yes,
maybe
but-
he raps, sorry, you're right.
Sorry.
She listens to his music and she knows his interviews. She's familiar with his interviews. So I'm just saying, based on that, that's sufficient for her to know his voice in any circumstance.
Yes, my lady, I do say so. Personally speaking, as I listen to music and I am a fan of certain producers as well, and in each song that a producer puts out or a DJ, when they do their mixes and their performances, you hear their voice throughout and also at a higher octave because DJs tend to speak louder when they're performing. So I do believe that being a long-standing fan of the appellant, she would be able to recognize his voice.
Okay.
So there's no difference between one's
Producers
voice
don't sing.
in terms of how it comes across in a rap or in a dancehall tune versus how they speak. You're saying there's no difference? Once you can identify the way the person raps or the person DJs, you know how they speak.
I am not claiming that there wouldn't be a slight difference, but I'm
Okay.
saying that once you are completely familiar with someone's voice, whether it be speaking, singing, or shouting, you should be able to identify a certain twang or their dialect or something in their voice.
So
that-
following from that
Yes,
and
my lord.
building from what you've said, what in this fact pattern establishes complete familiarity, as you say, on the part of this air witness? There is nothing to suggest that she has any familiarity with him when he's shouting in his intimate context. She may know him from interviews. Oftentimes persons assume a different way of speaking. Like for instance, in the Caribbean, we know persons in the public eye who, when a camera goes before them, they instantly fake an American accent. Or an English accent. But you see them playing dominoes down the road, that accent is noticeably absent. What in this fact pattern establishes the complete familiarity that you spoke to prior to my question?
My lord, my apologies if what I said gave the impression that I am claiming that she would have had complete and total 100% familiarity
Yes.
with the appellant's voice. May I beg the court's indulgence?
Okay, so what are you saying then? So
Sorry.
isn't the fact that she is bereft of this complete familiarity, she doesn't know him, she's not a friend of his? Can we agree on that? They're not friends.
Yes, I can
She's just a
agree.
fan.
Yes.
All she has heard in terms of the opportunities for her identifying his voice is via TV or radio, not in a personal context, in an intimate context. So shouldn't that inform or give us pause in terms of assessing her professed accuracy? Isn't that a limitation that a reasonable jury should consider?
Yes, my lord, it is that the jury should consider. However, I also want to point out that she is Blizzard's neighbor.
Yes.
So, and as Blizzard and the appellant were friends for over 15 years, it would be reasonable to assume that if they were friends for so long, wouldn't she have heard his voice when they were greeting each other when he came to visit or something of that sort?
But we're not talking about an identification of Blizzard's voice now. We're talking about, my question is touching and concerning her purporting to identify Vibe Skilly's voice, the accused.
Yes, my lord. The point I just made, I was trying to reference when the appellant would visit Blizzard, when they were speaking, through 15 years of knowing somebody and visiting somebody, there must have been a point where she may have heard his voice while he was visiting his longtime friend.
It's not for us to speculate, though. Shouldn't that have arisen from her testimony in terms of other context other than hearing via radio and watching interviews and watching or hearing his recording? Shouldn't that have been brought out in her testimony, and that's absent? So shouldn't that inform the court's treating with this evidence? Continue.
Thank you, my lord. My lords and my ladies, I will now address the third issue raised. The issue of whether the judge should have discharged the jury after a complaint made by a juror was brought to his attention. The appellant argues that the trial judge faltered by not discharging the jury after juror Cindy Shaky reported a threatening comment directed towards her. However, the respondent steadfastly contends that the judge acted within his discretionary powers and in accordance with established legal principles. The Jury Act of Antigua and Barbuda, specifically Section 18, clearly outlines the court's role in such situations. It states that if at any time during the trial a juror becomes aware of any matter that may cause a doubt as to their impartiality, they shall disclose it to the court. The court shall decide whether the juror may continue to serve on the jury. This provision does not mandate automatic dismissal of the jury. Rather, it empowers the judge to assess the situation and determine the appropriate course of action. In the case of the Queen v. Adams 1997, the House of Lords established that mere allegations of threats do not automatically invalidate a conviction, provided the judge takes suitable steps to mitigate any potential influence. In this case, the judge indeed took steps to alleviate potential influence. As to not allow the other jurors to be influenced in decision, the judge made the diligent decision to not alert the other jurors of the complaint made by juror Cindy Shaky. Here, the judge instructed the jury to focus solely on the evidence presented in court. Juror Shaky reported the incident promptly and continued her duties, indicating that she was not compromised. There was no solid evidence that the threat actually influenced her deliberations or caused her to deviate from her impartial role as a member of the jury.
So what you're saying is that what the judge did, the directions were sufficient?
Yes, my lord, based on his discretion.
And is there any authority you have that you can rely on to say that what the judge did was sufficient in the circumstances?
I would like to reference the authority I referenced before, Section 18 of the Jury Act.
Yes, continue, say it.
If at any time during the trial a juror becomes aware of any matter that may cause a doubt...
I'm so sorry to disturb you, Counsel. Act?
Yes, my lady.
Which cap?
10.
Thank you.
With the same 10.
Continue, she's waiting. So continue.
Continue.
No, I'm going
continue.
to answer, finishing the...
Yeah, you can continue. Yeah, continue your answer.
Yes. As to their impartiality, they shall disclose it to the court. The court shall decide whether the juror may continue to serve on the jury.
Yes, and do you have any case law that has applied what you've just said?
Case law for...
Any instance where this has arisen before and the court had to treat with something similar?
Yes, my lord. The case of Sean Campbell and 3 others versus the king.
Tell us about it.
In this case, there were multiple instances of jury influence. In one instance, a juror felt threatened because her son was threatened, and thus she asked to be excused from the court because she felt as though she would not be able to serve her duties as well as she should. So therefore, the judge allowed her to be dismissed, and the case went on as intended to proceed.
You said there were several instances.
Yes, there were other instances of, there was an instance of bribery, and there was another instance where the jury the jury discussed beyond mandated hours.
Okay, well, distinguish that case from the present case before us.
In the Sean Campbell case, the judge allowed the court proceedings to go on as intended, as per his discretion, while allowing one of the jurors to be dismissed. And similarly, in the Vibes-Skilly case, the judge took what Cindy Shaky said into consideration, and using his discretion, similarly, simply did not inform the other jurors of the complaint, allowing them to not be compromised by the supposed threat. Thank you, my lord. Here, the judge instructed the jury to focus solely on the evidence presented in court. Oh, my apologies, I skipped that. I said already. It must be highlighted that there is no evidence to support the relation of this supposed threat to Juror Shaky's role as a juror. The statement, "Gal, make sure you do the right thing," does not contain any context that makes it clear that the threatening statement made to Cindy Shaky was in accordance with the trial. The judge's decision to proceed rather than discharge the entire jury was a reasonable exercise of his discretion, balancing the need for fair trial with the avoidance of unnecessary disruption.
I'm sorry to interrupt.
Yes, ma'am.
Couldn't there have been an option for the judge to just discharge that particular juror as opposed to the entire panel?
Yes, my lord, but that was up to the judge's discretion.
And so do you think that the judge, in all the circumstances, exercised his discretion fairly?
Yes, my lady.
I'd just like to follow up on that. The judge, from what we're seeing, did not speak to the particular juror. It is the registrar that she spoke to who told the judge. Do you not think it would have been prudent for the judge to speak directly to Cindy Shaky before?
My lady, that particular point was not presented in the hypothetical brief, so I was unaware of that particular.
I'm just asking, what do you think?
Oh, what do I think? I steadfastly assert that the judge exercised rightful discretion in the decision that he made.
Thank you.
Thank you, my lady. It was a reasonable exercise of his discretion, balancing the need for a fair trial with the avoidance of unnecessary disruption. Alternatively, In conclusion, my apologies, the respondent unequivocally asserts that the appellant's conviction is irrefutably sound. The body of evidence presented was not merely strong, but a formidable structure of certainty.
Yeah, no,
That's fine.
yeah.
Finish your
Yeah,
point.
continue.
Thank you. Thank you, my lords and ladies. The judge's conduct was a precise and unwavering application of established legal principles, and the jury's verdict a just and inescapable conclusion. The appellant's inconsistent narratives, when juxtaposed with the starkly established motive and the unassailable reliability of the identification, forge an unbreakable chain of culpability. As the timeless maxim proclaims, the truth will out. And in this case, it emerges as a chain of evidence with devastating clarity, pointing to the appellant's guilt. Therefore, we implore this honorable court to dismiss the appeal and uphold the conviction of Adima Vibes Skilly Parker.
Thank you.
Thank you.
Thank you.
Time to compute my scores. Yes. Yes. No, one other moot, correct? Yes.
I don't have no more paper.
I have one extra. Oh, no, I thought I had one extra. I have only one more.
I don't.
1 verses 112.
Good afternoon. When you're ready, you may start.
Did you say Jessica Samuel?
Yes.
Jessica Samuel, lead counsel for the appellant. Beside me today is my esteemed co-counsel, Ocean Joseph. We appear before you today on behalf of our client, Mr. Adima Parker, who was convicted by a jury for the murder of Jerome Thompson. We humbly submit that his conviction is unsafe, unjust, and must be overturned. My lords and my ladies, we have copies of our written memorial for your attention. With the assistance of the clerk. Yes.
I'm impressed. Oh, thank you.
Thank you, counsel.
My lordships, we rely on 3 grounds of appeal. 1, the identification evidence renders this conviction unsafe. 2, the prosecution's circumstantial evidence was insufficient. And 3, the judge erred in law by failing to discharge the jury. I will be addressing the first 2 grounds of appeal, while my co-counsel will address the latter. If it pleases this court, may I please begin my submissions?
You may.
Round 1, unreliable identification evidence. My lords, the prosecution's case rested heavily on the testimony of Sandra Harris, who claimed to have identified Mr. Parker driving towards the victim's home at approximately 8 p.m. on the night of the murder. However, this identification is flawed for several reasons. The law regarding the quality and reliability of identification evidence is well established and not in dispute. This court continues to be guided by the celebrated case of Turnbull versus the Queen, in which the English Court of Appeal highlighted key considerations for assessing identification evidence. My lords, in the interest of time, I will highlight just a few Turnbull guidelines. 1, how long did the witness have to observe the suspect? 2, were there any obstructions in the witness's view? And 3, what were the lighting conditions? Applying these principles to the present case, it is respectfully submitted that 1, Sandra's observations were fleeting. 2, her view of the individual she allegedly saw was obstructed by heavy rain. And 3, while it is not in dispute that the roads were brightly lit, what benefit was it when Sandra attempted to identify the individual in a car that was speeding away while she too was driving and through heavy rain? I ask this court, did the lighting truly make a difference? My lords, when the fog of doubt surrounds identification, it cannot be the foundation of a conviction. It was the evidence of Sandra that she knew my client and the victim for a long time, and it is arguable that it was technically a case of recognition as opposed to identification. However, we would like to draw to the court's attention the case of the Queen versus Bentley, where the court ruled that although recognition evidence may be more reliable, it still requires caution and should not be treated as automatically trustworthy. However, whether the evidence pertains to identification or recognition, we submit that it is fundamentally flawed and should not have been allowed to convict the appellant. Ground 2, insufficiency.
If I may, so are you saying that the evidence of eyewitness identification is so tenuous that it should not have been left to the jury in the first place? Is that your argument?
Thank you for that question, my lord.
What we are saying is you need to know the true identity of the person. You need to be sure of the person that you say that you see because you cannot pass any assumptions to who you're seeing. So you must be sure that the person is who they say they are.
That's the essence of Turnbull, that you give a direction, that
Yes.
you're treating with a class of evidence
Yes.
that, based on human experience, is problematic.
Yes.
But my question to you, though, separate and apart from Turnbull, are you saying that the evidence in this case was so deficient or so insufficient that it really did not amount to proper identification evidence
Yes,
to
my
be
lord.
left to the jury? Is
Yes,
that your
my lord.
answer? Okay. Continue.
Ground 2, insufficiency of circumstantial evidence. Furthermore, my lords, we now turn to the fragile web of circumstantial evidence that the prosecution used to convict Mr. Parker. A web made of thread so thin it cannot hold the weight of a man's freedom. None of the evidence was strong enough to prove guilt beyond a reasonable doubt. It was submitted that while the Crown presented multiple pieces of circumstantial evidence, these strands of evidence are individually weak, and even when put together, do not exclude all reasonable doubt. Regarding Nosy Nancy's
So what
testimony,
you're saying is that the evidence, circumstantial evidence that has been presented can draw, other conclusions can be drawn from that evidence that has been presented?
yes, my lord.
Very well.
Regarding Nosy Nancy's testimony, the defense contends her ability to identify Mr. Parker's voice was flawed. Her familiarity with his voice was primarily through music. A musical performance, often amplified, is likely to sound different to an in-person conversation. A singer on stage is not the same as the man in the dark. Nosy Nancy only heard 4 words, "You are nothing without me." Just as the sun rises in the east and sets in the west, this is our sure submission that it is not sufficient for voice identification. No recording of the voice Nancy claimed to have heard was available for forensic analysis, making it impossible to verify the identity of the speaker.
So can I ask you, would a voice ID parade be useful in this instance?
Thank you for that question, milady. Could you repeat your question?
Would a voice ID parade, would it have been helpful?
Yes, milady.
And can you explain why?
Thank you for that question. The voice ID would have been helpful in this case because Nosy Nancy did not see the person who she claimed to have heard, only a voice and with just a few words.
Well, considering that Nosy Nancy has been listening arduously to this particular artist for so many years, and not just his music, but his interviews, could you not say that she really could identify properly the voice of Mr. Parker?
Thank you for that question, milady. Even though Nosy Nancy heard his voice in his music and in interviews, as we submitted, he could still be using a persona in his interviews and in his songs, and it will obviously sound different to his voice in an in-person conversation.
Very well, continue.
So tie that to your submission regarding the ear witness parade. How would that have helped?
She was not sure. Nosy Nancy did not hear his in-person voice. She was only familiar with his voice through music. So she would not be sure that it was his voice that he heard, that she heard. It could be someone else altogether.
Continue.
The argument Nancy overheard could have involved someone else altogether. My lordships, 4 words torn from an unknown moment, are being used to paint a picture we cannot even see. That is not evidence, that is speculation. Similarly, the presence of Mr. Parker's fingerprint on the award plaque is neither conclusive nor suggestive of guilt. It was Mr. Parker's fingerprint, but we do not run from that, because he was there at 6 p.m. earlier that evening, holding that award plaque while reminiscing about his partnerships. That is evidence of memory, far from sinister, but speak to a shared history and friendship, not to murder. The defense further highlights inconsistencies in the timeline. Mr. Parker's evidence is that he left Mr. Thompson's villa at 6 p.m., whereas Sandra Harris, whose evidence we submit is unreliable, claimed to have seen someone resembling him at around 8 p.m., in the absence of corroboration and reliable recognition evidence. The Crown's timeline remains speculative. We are being asked to believe in possibility and not proof. In the case of the Queen versus Taylor, Weaver, and Donovan, the court held that circumstantial evidence should be so strong that it excludes all reasonable hypotheses, except the defendant's guilt. The evidence presented by the prosecution did not achieve this. My lords, circumstantial evidence should not lead to a circumstantial conviction. This honorable court is not a theater for fiction. It is a temple of justice, and justice demands more than whispers in the dark and unidentified footprints hours before. It demands clarity, it demands certainty, and it demands evidence that can withstand the storm of scrutiny. Unless I could be of further assistance to this court, these are the extent of my submission on the first two grounds. I will now turn over to my co-counsel who will address the third ground. Thank you.
Thank you.
Thank you.
May it please this honorable court. As stated by the lead counsel, my name is Oceanique Joseph, and I too appear on behalf of the appellant. I will now address the third ground, being whether the trial judge should have discharged the jury. And, my lords, we respectfully submit that he should have. To briefly remind the court of the facts surrounding this ground, one afternoon, while outside the courtroom, juror number 7, Miss Cindy Shaky, was approached by an unknown individual. He attempted to influence her. She received a threat stating, and I quote, "Gal, make sure you do the right thing." My lords,
I have a question to interrupt you. What say you to this point? A fair trial, and I'm quoting from what would be persuasive authority in these parts, binding Supreme Court of Canada case. A fair trial does not mean a perfect trial. Inevitably, unusual occurrences will manifest in a case. Life is, things sometimes go awry. And we have to make allowance for that. A fair trial does not mean a perfect trial. So, notwithstanding the fact that the trial wasn't perfect, all that needs to be done is a fair trial. In light of that, what say you regarding this particular jury issue?
okay. Thank you for that question, my lord. In accordance to the Constitution of Antigua and Barbuda, of 1981, section 15.1, it states, I crave your indulgence, my lord.
Take your time. And are you referring to your written brief?
I am.
So could you advert us to the relevant page, please, so we can follow along?
Okay. My lords? Yes, my lady. Turn your attention to page 14
Yes.
of the memorial. Paragraph 3 says, of the Jury Act 2009, it outlines the circumstances under which such a discharge of jury may occur.
May occur. Continue.
However, common law also permits the discharge of a jury or juror in cases of impropriety or misconduct. In accordance with the Queen and Smith, it was held that the trial judge has discretion in deciding whether to discharge a juror or the entire jury when impartiality is an issue. The judge must balance the seriousness of the threat against the need to maintain public confidence in the justice system.
Oh, Ms. Joseph, can I just stop you for a minute there? The words uttered by this supposed person to Ms. Shaky, did that really constitute a threat?
Thank you for that question, my lady. To decide whether the words stated to Ms. Shaky would constitute to a threat, it would be a test to whether a fair-minded individual, having received or heard those words, would constitute that they were intended to intimidate or force the individual to make a decision.
And so you think that would follow up with something more? But if you don't comply, then this
Yes,
will
ma'am.
happen to you?
Yes, ma'am.
And in this case, that is absent.
That is true, my lady. However, the trial judge it's at the trial judge's discretion to investigate to what extent the threat hampered the said juror or the entire jury.
And can you give me the authority for that?
Thank you, my lady. I crave your indulgence, my lady.
Very well.
In accordance to the medicaments test approved in Porter and McGill, it states, sorry.
Are you on page 14, paragraph 4 thereof?
I am, my lord.
Whether a fair-minded and informed observer, is that?
Yes, my lord.
Okay.
Whether a fair-minded and informed observer, having considered all the relevant facts, would conclude that there was a real possibility that the juror or jurors were biased.
So, in law, based on the treatment in the jurisprudence, the words intimidate keeps cropping up. Would you agree?
I do, my lord.
So, I just did a cursor search on dictionary.com. Crave your indulgence. And intimidate, according to dictionary.com, and it's taken from the Oxford language, definitions of Oxford languages, to frighten or overawe, especially in order to make them do what one wants. So let us turn to the instant facts. Can it not be said that all that was done was just a vernacular invocation or appeal to this person to do the right thing, nothing more, which is almost akin to what a judge cautions a jury? You ought to decide, reach your verdict based on a evaluation of the evidence that you hear, not from any newspaper source or anything extraneous to this trial. The right thing is to hearken to the evidence and nothing more.
That is true, my lord. However, the situation surrounding the meet with juror number 7 and the unknown individual raises suspicion. It is to be analyzed that a random individual approaches a juror outside of a supermarket and utters those words. Wouldn't it raise suspicion?
Suspicion for or against, in what way?
Given the circumstances, having knowledge that she is a juror, and then receiving those words, "Gal, you better do the right thing," the judge should have investigated, because juror number 7, Ms. Cindy Shaky, she reported the incident to the registrar, and the registrar then informed the trial judge, and he basically disregarded the entire situation.
But I'm so sorry, but if it is that you're saying that the judge should have investigated, can you just kind of detail what that investigation would include? Because did she know this individual before?
Thank you for that question, my lady. Well, those are the questions that the trial judge should have asked, and the answers would have been in the ear had he followed judicial procedures and did a proper inquiry.
But in the instance also where this particular juror also did not portray this message to any other juror on the panel, was the warning given by the judge that they should be mindful of their oath, wasn't that sufficient?
It was not sufficient. It is human nature. When an individual is made aware of a situation, it is hard to contain that within yourself. There is no proof that she did not inform the other jurors. There's no proof that she did not tell a family member at home the situation that occurred between herself and the stranger. Therefore, the trial judge should have conducted an investigation to find out.
And does any recent case come to mind that would support this strong assertion?
Yes, my lord. In the case of R. and Smith, the Queen and Smith, it was held that the trial judge has discretion in deciding whether to discharge a juror or the entire jury when impartiality is an issue. The judge must balance the seriousness of the threat against the need to maintain public confidence in the justice system.
So you cite Smith, which is a Court of Appeal decision arising from the UK.
Yes, sir.
Persuasive effect. Any binding recent authority comes to mind on this issue?
Okay, binding. I crave your indulgence, my lord. English and Wales Courts of Appeal.
If you don't have any, that's fine. I just wanted to confirm.
No, my lord, we have, in the Jamaican case of Lang and the Queen, the Jamaican Court of Appeal, Criminal Law 11.
Yes, I see that.
May I proceed?
Proceed, please.
Okay. My lords, the defendant has a constitutional right to a fair trial by an independent and impartial jury. This fundamental right must be safeguarded, as even the perception of bias or coercion can undermine the conviction and, more importantly, public confidence in the justice system. The trial judge's failure to discharge the jury will therefore submit breached our client's constitutional rights. In this matter, juror Cindy Shaky was approached by an unknown individual who attempted to influence her. She was visibly shaken, yet the trial judge failed.
Just before you continue, wouldn't it be more appropriate for the judge to have just discharged that one juror instead of the entire panel and having to restart the entire process?
Thank you for that question, my lord. That links back to our statement where we mentioned that it is human nature. The judge did not conduct an inquiry directly to Miss Cindy Shaky to find out if she had spoken to any of the other jurors.
But the evidence there is that she did not.
But the trial judge did not justify that for himself.
So just to follow up on that, you're saying there is a duty on the trial judge to probe further.
Yes, my lord.
Just simply taking it at face value was insufficient in light of the importance of this issue to
Yes.
the fair trial
Yes,
right
my
of the
lord.
accused. I hear you. I hear you. Continue.
Can I continue?
Yes, please.
Okay. Instead, the trial judge merely instructed the jury to adhere to their oath without making any direct inquiries. We therefore submit that his actions were insufficient. My lords, where justice is threatened, fairness cannot stand. Case law, including the Queen and Smith and the Queen and Mercer, makes it clear that where there is a realistic suspicion of jury tampering or intimidation, the judge has a duty to investigate. My lords, turn your attention to page 14, paragraph 4 of the memorial, please.
I'm there.
The last two sentences state, whether a fair-minded and informed observer having knowledge of the relevant facts would conclude that there was a real possibility of bias. The medicaments test approved in Porter and McGill justifies this point. Again, my lords, it is respectfully submitted that if a fair-minded and informed observer had knowledge of the threat made to Ms. Shaky and the trial judge's flagrant inaction, indeed, they would conclude that there was a real possibility of bias. In the Jamaican case of Leng and the Queen, the Court of Appeal emphasized that failings to conduct proper inquiry could result in a miscarriage of justice. This case also highlighted that in the absence of statutes, court rules, or practice direction, a judge has discretion in determining the procedure for addressing juror misconduct or impropriety. As in Jamaica, there is no established procedure in Antigua and Barbuda to guide the judges in this regard. However, while the decision to discharge a juror lies within the judge's discretion, this discretion must be exercised judiciously. In this case, the judge failed to investigate the incident involving Ms. Shaky. Furthermore, defense counsel was not informed of the threat made against the juror until the trial had concluded. My lords, the judge's failure to notify counsel cannot be considered a judicious exercise of discretion. Given these circumstances, the judge's failure to investigate the juror or jury as a whole, it casts serious doubts on the fairness of the trial. The extent of the threat made to Ms. Shaky remains unknown, and we cannot determine whether the entire jury was compromised. Consequently, the jury should have never been entrusted with delivering a verdict. They ought to have been discharged, both in the interests of justice and to uphold the integrity of the verdict. My lords, fear should never sit in the jury box, because a trial by intimidation is no trial at all. My lords, the appellants submit that the conviction of Dima Parker for the murder of Jerome Blizzard Thompson rests on insufficient circumstantial evidence and unreliable identification evidence. Sandra Harris's identification was made under poor weather conditions, raising serious doubts about its reliability. Furthermore, the prosecution's circumstantial evidence, while suggestive, fails to exclude alternative explanations for the events leading to Mr. Thompson's death. Compounding these issues is the matter of juror intimidation. The reported threat to juror Cindy Shaky likely compromised the jury's impartiality, an essential safeguard for a fair trial. The trial judge's failure to properly address this issue or assess its impacts renders the conviction unsafe. Given these concerns, the weaknesses of the identification evidence, the circumstantial nature of the prosecution's case, and the potential for jury bias, the conviction cannot be considered safe. It is imperative that the Court of Appeal scrutinizes these failings to uphold the integrity of the judicial process and ensure justice is served. My lords, in light of the issues raised, arguments advanced, and authorities cited, it is our humble and respectful request that the court declares the appellant's conviction quashed. Unless we can be of further assistance to this court, this is the extent of the appellant's submissions.
Thank you, Ms. Joseph, for your submissions.
When you're ready, you can begin.
Grateful Milady. May it please your lordships and your ladyships, my name is Adhara Salfarli. With me,
Please, the names are very important.
O'Hara.
Adhara Salfarli.
Can you spell the last name?
S-A-L-F-A-R-L-I-E.
L-I-E?
Yes.
And your first initial?
A.
A.
Yes.
Very well.
Grateful, my lord. With me is Abia Talisford.
Spell
And
the last name,
together-
please, just to make sure we have it.
T-E-L-E-S-F-O-R-D.
Thank you.
And together we appear on behalf of the Crown. My apologies. My lords, my ladies, before I proceed with my substantive arguments, written submissions were indeed filed on this matter on behalf of the Crown on the 16th day of February 2025, together with our bundle of authorities. I just want to confirm with the court that my lords and my ladies have received those written submissions and authorities.
No.
No?
Oh, we haven't. But we are supposed to, though.
Well, my lords and my ladies, I have one copy. I do not have 3 extra.
Yeah, I know. We should have said yes for the sake of we have received it, you see.
Okay. Grateful, my lord. For the purposes of this hearing, we
Yes.
continue to rely on those written submissions together with the authorities.
Very
And the authorities that we are going to reference in our oral arguments are contained in our bundle of authorities that were indeed filed.
If I may, can you stop timing? The submissions that you refer to, do you have an extra copy?
Yes, I have an
It
extra
may
copy.
assist us to have one copy if needs be. We can circulate it. Let's have it. Out of an abundance of caution in light of. Thank you. You may continue.
Grateful, my lord. We commend the authorities to the court for its consideration in this matter. My lords, my ladies, this appeal arises from a conviction in the court below, whereby the appellant was convicted for the offense of the gruesome murder of the victim, Jerome Blizzard Thompson. The jurisdiction of this court was invoked by the appellant pursuant to Section 40, subsection 1 of the Eastern Caribbean Supreme Court Act, Chapter 143. Mr. Parker, the appellant in this case, was indeed convicted of the offense of murder by a jury of his peers. We respectfully submit that this conviction should be upheld and the appeal of Mr. Parker is refused. And we say this, my lords and my ladies, for the following 3 reasons. Firstly, the identification evidence of the witnesses reinforces the safety of the conviction. Secondly, the circumstantial evidence relied on by the Crown was sufficient to ground the conviction. Thirdly, the judge exercised proper discretion by not discharging the jury because of a complaint made by a juror. My ladies and my lords, I will address the first ground of appeal. My co-counsel and I will address the second ground of appeal, and the third ground of appeal will be addressed by my co-counsel. The offense of murder, my lords and my ladies, is so well known to this court that it need not be repeated. But, even at the risk of sounding redundant, may the court permit me to remind it that murder requires unlawful killing, which constitutes the actus reus, malice aforethought, whether expressed or implied, and mental capacity, which constitutes the mens rea. This definition is in accordance with the learned authors of Blackstone's commentaries on the laws of England. Therefore, my lords and my ladies, the ingredients for murder have definitely been satisfied. The identification evidence of the witnesses reinforces the safety of the conviction. My lords, my ladies, Sandra Harris's eyewitness identification of the appellant was reliable and admissible under the guidelines established in the Queen against Turnbull. Lord Widgery, Chief Justice, considered factors such as observation, duration, distance, lighting, obstructions, and familiarity between the witness and the accused. Sandra witnessed Vibe Skilly driving towards Blizzard's villa around 8 p.m. This was not merely a case of a fleeting glance, as the appellant would want you to believe. The witness had the opportunity to see the appellant for an entire 5 seconds. I would like to invite this court to actually consider how long 5 seconds is. 1 Mississippi, 2 Mississippi, 3 Mississippi, 4 Mississippi, 5 Mississippi. The appellant was
And
not
can
a
I interrupt you?
stranger. Yes,
You're
Malia.
saying how long 5 seconds is. You think that's sufficient with heavy rain for someone who's driving to make a
Yes.
positive identification?
Yes, my lady. This was indeed a positive identification, as it was a case where she positively identified someone whom she was familiar with for 15 years, my lady.
In 5 seconds of heavy rain? as
Yes,
she's
5
driving.
seconds was sufficient, my lady.
You would agree with me that 5 seconds in circumstances where you're standing on a street corner is different from 5 seconds when you're driving a motor vehicle in heavy rain.
Yes, my lord. Well, considering all the other factors such as the untinted windows of the vehicle and her familiarity with the appellant and the well-lit street would allow the witness to positively identify the appellant.
Would an identification parade have been useful in this case, given the facts?
No, my lord.
And if not, why do you say so?
I say so, my lord, because it is a case of recognition, not trying to pinpoint a particular person.
Okay. And any authority that comes to mind that would undergird or support your...
The Queen against Turnbull, my lord.
Okay.
Yes, my lord.
But
Thank you,
before
Mike.
continue, counsel, just to add, the appellant was also allegedly speeding.
Mhm.
Wouldn't that also have obstructed Sandra's view?
Yes, my lady, that would have obstructed Sandra's view. However, as I've stated before, this was a case of recognition.
And I agree with you, counsel.
Mhm.
But when you take all these circumstances and you put them together, so it was at night,
Mhm.
it was raining heavily,
Yes.
and he was speeding. Was that sufficient?
It was sufficient to the Crown, yes, my lady.
Continue.
Thank you. Grateful, my lady. Yes, it was raining, but when you consider all the other factors, this was a positive visual identification, as I've said before. The conviction of the appellant was not based on positive visual identification alone, but rather also on the other circumstantial evidence, which, my lords and my ladies, brings me to my second ground of appeal. The circumstantial evidence relied on by the Crown was sufficient to ground the conviction. Nosy Nancy's voice recognition proved Vibe Skilly's presence at the victim's villa and his role in Blizzard's murder. The Queen against Aaron Stanislaus affirmed that a witness may identify a recognizable voice, while J. Mary Chin against the Queen and Fitzroy Jarvis against the Queen upheld circumstantial evidence as grounds for conviction.
Yes. Are you saying that what Ms. Nosy heard was sufficient to establish voice identification in the circumstances?
Not alone, my lord, but rather considering all the other circumstantial evidence, my lord, together, it is sufficient to ground the
But
conviction.
dealing with the voice identification,
Yes, my
are you
lord.
saying what she heard in the moment there was sufficient to establish a proper voice identification outside of the other circumstantial evidence?
Yes, my lord.
Why is that?
Because this is a case of Nosy Nancy giving evidence of what she heard. Therefore, she is a witness of fact and not a witness of opinion. It is not a case where voice recordings were played and she had to identify the voice, but rather she gave evidence of what she heard.
But
Yes.
to follow up on that, you say talk about witness, so I don't know if my friend was finished.
No, well, I was going to say, now that you've indicated that, but what about this particular situation? What about the circumstances that is it that the court can accept what Miss Nosy Nancy is saying amounts to proper voice identification? What on the facts establish that?
That she was an avid fan of Vibe Skilly, or rather the appellant, and that she was acquainted with his voice, my lord.
And do you have any authority addressing something similar to this?
I crave your indulgence, my lord. Yes, the case of Aaron Stanislaus against the Queen.
Could you repeat that?
Sorry. Aaron Stanislaus against the Queen.
Clause.
Against the Queen. And in this case, it stated that a witness may identify a recognizable voice. And in this case, she was able to recognize this voice.
Very well. Continue.
So my question is, and your opponent, the appellants, in their brief, advert to the case of Queen against the wrong brief. Baptiste and Edwards. And you don't have it in your brief, but the principle thereof, that case establishes how inherently problematic ear witness identification is. How it is similar to Turnbull type eyewitness identification. Witnesses can be as cocksure, they're positive, they're willing to stamp with certainty. I know that voice. I recognize that voice. But notwithstanding that, honest though they be, reasonable and honest witnesses may be mistaken,
Yes.
particularly when one recognizes that empirical tests have been done where persons mistake the voices of persons who they intimate relations, because voices sound different over the phone depending on the context, different over the phone, different over the radio vis-a-vis in person.
Yes, my lord.
So you will agree that notwithstanding the certainty with which the witness asserted that, yes, I know this person, notwithstanding the reality that she was a fan and that she has a history of listening to Vibe Skilly, that in itself, without more, does not stamp it with fact established. So that being so, are there any features other than her certainty that you would say support the reliability of this identification?
No, my lord, there are no other features. However, Nosy Nancy's voice recognition evidence was not relied on for her expertise, as she's not a speech pathologist, but rather it was, as I said before, that she is a witness of fact. She was merely giving evidence that she heard.
Okay, but you keep on using this rubric of witness of fact. But whether or not the witness is a witness of fact is for a properly instructed jury to decide. And the jury ought to be informed of the caution in which this evidence should be approached. Will you acknowledge that there are instances in this case that would necessitate caution, separate and apart from Nancy's assertion that this is a fact?
Could you repeat that question, my lord? I'm sorry.
Notwithstanding Nosy Nancy's assertion or 100% certainty as she believes it to be. There are circumstances, like, for instance, the fact that we're talking about 4 words, aren't we?
Yes.
Only those 4 words. That should inspire caution in terms of how you approach. You can't just take the assertion that this is a fact at face value. You have to look for indicia of reliability. Do you agree with me?
Yes, I agree.
So
my
what
lord.
are the indicia of reliability other than her professed knowledge?
I believe, my lord, that if it was more than 4 words, that she would have been firm in her recognition of the appellant, my lord. So, duration.
It wasn't more you're nothing without me?
Sorry, my lord?
Are you saying that the evidence is that she claimed to have identified Vibe Skillis stating you're nothing without me?
Yes, my lord.
More than that was what constituted the voice identification in this case?
No, my lord.
So isn't that 4 words?
Yes, it's 4 words, my lord.
Very well. Continue.
My lords, my ladies, Nosy Nancy's frequent exposure to Vibe Skilly's music strengthened her ability to identify his voice, placing him at the crime scene. Together, voice identification and circumstantial evidence maintains the jury's conviction of the court below that Vibe Skilly murdered Blizzard. The fingerprint evidence found on the award plaque was sufficient to ground the conviction. Omari Philip against the King asserted that when there is weak or no identification evidence, forensic evidence plays a crucial role in determining the guilt or innocence of the accused. This is not an admission that the visual identification is weak. In fact, the visual identification evidence, as I've stated before, is quite compelling, and that was accepted by the jury. But in addition to that strong evidence, the Crown is relying on the fingerprint evidence, which, together with all the other circumstances, was sufficient to ground this conviction. The fingerprint evidence is significant because it was found on the award plaque, the murder weapon, which caused Blizzard to cruelly suffer from blunt force trauma to the head. Although the appellant claimed that he had previously handled the plaque while reminiscing about his partnership with the deceased, the presence of his fingerprints suggests that he held the award at some point before or during the incident. It could very well be that the appellant left the deceased's villa at 6 p.m., but he surely returned at 8 p.m. The visual identification and voice recognition evidence places him at the villa way after 6 p.m. Even if his version of events is truthful in any aspect, he is still leaving out crucial details.
So just before you continue, he's saying he left at about 6 p.m. and the other witnesses are saying they either saw him going there after 8 p.m. or heard him there after 8 p.m. This would amount to, on the Crown's part, a lie, that he would be telling a lie.
Yes, my lord.
Could the Crown rightfully rely on this lie?
Can you repeat the question, my lord?
Is the Crown able to rely on the lie that he told about him leaving at 6 when the witnesses are saying he was there at 8?
Yes, we're able to rely on the lie, my lord.
How would the Crown rely on that
Because
lie?
the evidence of, well, the visual identification evidence and the voice recognition evidence places him back at the villa after 6 p.m.
Very well. Continue.
Thank you, my lord. Grateful.
But even if he lied about his presence there at 8 p.m., does that inexorably lead to the conclusion that he did this? Could it not be that he is there and he's ashamed, he knows how it might look, so he just lies about it for this purpose while not being culpable?
Well, my lord, taking all the circumstantial evidence together, it most definitely places him at the crime scene at this time, my lord.
Okay, continue.
Grateful, my lord. The evidentiary factors, which include the visual identification, the voice recognition evidence, and the fingerprint evidence, when put together, places the appellant at the crime scene. All of these evidentiary aspects of the case demonstrate, at the very least, that the actus reus for the offense of murder was in fact satisfied, and the jury found him guilty on that basis. With your leave, my lords and my ladies, may the court permit my co-counsel to continue.
Just before you end.
Yes, my lord.
So you're saying that all the strands of evidence coming together, it points to one thing, that Vibes Skilly is guilty of this offense.
Yes, my lord.
Though it's not in the brief, what if it was a situation where Blizzard had previously reported Sandra to the police about her threatening him, and this was like 2 days before the incident? Would that have an impact on your case?
No, my lord.
Why wouldn't it?
Because it was not that Sandra was in his villa. She merely saw the appellant driving towards his villa. So I do not believe that even if she made a threat to him 2 days prior to the incident, that it would have an impact on the case.
And would it have an impact on her evidence that she gave about seeing Vibes Skilly going to Blizzard's home that night?
No, my lord, because she only mentions Blizzard's villa, not Blizzard himself.
Very well.
In that way.
Proceed.
Okay. With your leave, my lord and my ladies, may the court permit my co-counsel to continue our argument on why the circumstantial evidence relied on by the Crown was sufficient to ground the conviction?
Very well.
Grateful, my lord.
This is Miss B. Tellisford.
A. Tellisford, my lord.
Oh, my handwriting is confusing me. A. Tellisford, thank you.
No problem, my lord.
For the record, my lords and my ladies, my name is Abia Tellisford, as previously introduced by my co-counsel at Hara Salfali. I will be addressing the appellant's malice aforethought, as well as the third ground of appeal, being that the judge correctly exercised proper discretion by not dismissing the jury after receiving a complaint from a juror. May I proceed?
Certainly.
Grateful, my lords and my ladies. On the issue of the sufficiency of the circumstantial evidence, I will now discuss the malice aforethought of the appellant. As stated previously by my co-counsel, an essential element in proving murder is malice aforethought, or the intent to kill or cause grievous bodily harm, as stated by the learned author Blackstone. The evidence of a strained relationship between the deceased and the appellant, as well as the heated argument witnessed by the neighbors the night before the deceased was found brutally murdered, contributed to the appellant's malice aforethought in the murder of the victim, Jerome Thompson. It was no secret, my lords and my ladies, that the appellant was frustrated with the deceased's want for more recognition and financial compensation. In fact, close friends and colleagues of the men recalled heated arguments between them, with some even suggesting that their relationship, or rather their partnership, was on the brink of dissolving. With this in mind, my lord and my ladies, I kindly ask you to reflect with me on the night before the appellant was, the deceased, was found brutally murdered. It was the evidence of neighbors that they heard loud voices and sounds of argument coming from the deceased villa shortly after 8 p.m. It was also the evidence of one neighbor, Nosy Nancy, that she heard the deceased, Mr. Thompson, shout, "You can't control me, and you'll never get away with this." It was also her evidence that the appellant replied to this, saying, "You're nothing without me." My lords and my ladies, I cannot emphasize enough how compelling this evidence is. "You can't control me and you'll never get away with this" directly relates to the deceased's previous want for more recognition and financial compensation, to which the appellant refused to give him. "You're nothing without me," shows that the appellant was trying to prove his dominance over Mr. Thompson. The evidence of this heated argument and the previous reports of tension between the two men highlights the appellant's undeniable motive for the murder of Jerome Thompson. Further, the overturned furniture and broken glass found in the villa suggested a violent struggle, and the use of an award plaque as a violent weapon for a brutal murder highlighted the appellant's intention for murder driven by this same motive.
I'm sorry, I'm not following you. What is the motive? You keep saying this motive.
Yes, my lady.
That you'll be nothing without me?
The motive of the appellant is shown or highlighted by the tension between the two men and their history of a disagreement because of the deceased's want for more recognition and financial compensation, as well as the arguments heard by Nosy Nancy and other neighbors the night before the deceased was found brutally murdered.
Okay, thank you.
Of course, my lady. This was clear satisfaction of the mental element, and the actus reus element was satisfied by the circumstantial evidence discussed by my co-counsel previously. This evidence was so compelling, my lords and my ladies, that it was accepted by the jury, and it is on this basis they unanimously convicted the appellant. It is for these...
You use the word compelling.
Yes, my lord.
We're talking about a case here where the murder weapon, according to the Crown, there's no evidence of any blood being found on it. All the facts establish is that blunt force trauma
Yes, my
was
lord.
the cause of death. So here it is, we have this reality where we're not talking about forensic evidence other than the fingerprint. And then we have these, to use the analogy of rope, we have the strand of purported eyewitness evidence. We have the strand purported ear witness evidence. What makes this case a compelling case?
My lord, this case is compelling because all of the evidence that the prosecution relied on. It was not only, the evidence is not to be looked at in isolation, my lord, but rather all the facts, all the evidence from the witnesses shows that Vibe Skilly, or rather the appellant, is responsible for the murder of Jerome Thompson. He was identified by Sandra Harris before 8 p.m. He was heard by the neighbors and Nosy Nancy shortly after 8 p.m. and his fingerprint was found on the award plaque.
Wouldn't you agree with me that a rope is as strong as its strands? And if the individual strands, although together they're stronger combined, but if the individual strands are weak to begin with, they only come together to produce a weak rope?
My lord, I do not agree with that because I think even the evidence on its own still supports that the appellant is responsible for the murder of Jerome Thompson.
Okay, continue.
Grateful, my lord. It is for these reasons, my ladies and my lords, that we submit that the circumstantial evidence was in fact sufficient to ground the conviction. Regarding the third ground of appeal, my lords and my ladies, we submit that the judge properly exercised discretion by not discharging the jury after receiving a complaint from a juror. The well-cited case of the Queen against Blackwell established that the duty of a judge lies within his or her discretion, and after questioning, he or she will decide whether to discharge the entire jury. Yes, my lord.
Yes, it comes readily to mind, having had sight of page 9 of your brief here, where underneath the duty of the judge, you submit. The issue is focused on whether the judge properly exercised discretion. So there's no dispute that the judge had a discretion, but it is for determination whether this discretion was properly exercised. Here it is, you put, quoting Queen and Blackwell, if there is any realistic suspicion that the jury or one of its members has been approached, tampered with, or intimidated, it is the duty of the trial judge to investigate the matter, as established in R versus Blackwell. Was the duty of the trial judge to investigate the matter satisfied in the instant case?
My lord, the trial judge did not investigate the matter. And we believe that the judge did exercise his discretion by not investigating the matter, as there was no real threat made to Cindy Shaky. There was no evidence of intimidation. Therefore, he used his discretion that since there was no evidence of intimidation, that he would continue with the trial.
I have a follow-up question. Who decides whether there was any real threat? Is it a purely objective test that you looking on, look at the circumstances and you say that doesn't constitute a threat? Or is it important, bearing in mind that the juror in question is tasked with this very important and serious task, if they somehow are subject to use a word, they are placed in a context where their impartiality is rendered into question. Bearing in mind we're talking about the optics of the situation, doesn't that necessitate some probing on the part of the judge? Is it purely a matter of looking objectively and deeming that that shouldn't constitute a threat?
Well, my lord.
Are you understanding my question?
Can you repeat the question, please? I was just going to ask you to.
You're stating, you assert that what was done or what was stated in the instant case does not constitute a threat.
Yes, my lord.
Is it purely a matter of an objective determination of what is a threat versus what is not a threat? Or does the mere likelihood or probability of this person being so subjectively affected that their impartiality is affected in itself cause for probing?
Well, my lord, we rely on the fact that this instance did not warrant investigation, as there was no threat made. And the judge did not, even though he did not properly investigate the matter, he did give a direction to the jury saying to stick to your oath and make the decision based on what you heard in court.
So you used the word that he didn't proper, so there was some impropriety on his part, but you're saying that is not sufficient to impugn what he did or to render the conviction unsafe.
Yes, my lord, as he did use his discretion, and this instance would not warrant the discharging of the entire jury.
Final question to follow.
Yes, my lord.
So you're saying it didn't constitute a threat, it doesn't objectively constitute a threat. What if Ms. Shaky not only constituted this a threat, but whispered to her fellow jurors that, hey, this happened, and because of this, it's likely that X or Y or Z. What if that were the case? Would that have been a problem to the safety of the verdict? And it's hypothetical.
Oh,
I'm not saying it happened, just to be clear. I'm posing a hypothetical question. What if Cindy Shaky, Ms. Shaky, so constituted this a threat subjectively, and not only did that, constituted a threat to herself, but she shared this with her fellow jurors? Would that change your perception or your view as to the legal efficacy of the situation?
No, my lord. Well, really and truly, my lord, I'm not in a position to
comment on that. Well, while I do acknowledge your hypothetical question,
Yes.
in this case, she did not whisper to the jury. Nobody knew except the court registrar. Therefore, going based off of that, we still submit that the judge used his proper discretion by not discharging the entire jury.
So based on what you just said, should the judge have discharged that particular juror?
No, milady.
And why do you say that?
Because, milady, the judge should not have discharged Cindy Shaky because I will go back to my previous argument that there was no evidence of jury intimidation. Because as established in the case of Calvesta Herbert, the Director of Public Prosecutions against Calvesta Herbert et al., in order for jury intimidation to be established, there must be evidence of coercion, bribery, or influence or pressure to influence a verdict. And none of that was shown in the case here and the alleged threats made to Cindy Shaky, even though we submit that that was not a threat.
So the medicaments test that you referred to at page 10.
My lord, the medicaments test, while we do have it in our written submissions, we do not have it in our oral submissions, as we realize that we do not want to, that this case is not necessity to rely on, it's not a necessary authority to rely on for our oral submissions.
So the medicaments test has no bearing on the decision of this matter? Is that your submission?
Yes, my lord, because it didn't even get to the point to where Cindy Shaky was biased. She was impartial. Therefore, the medicaments test does not have to be applied in this case.
Okay. Continue.
Thank you, my lord. Grateful, my lord. We commend also the authority of the state against Baichidin, which established that a high degree of necessity must be established in order to justify discharging a juror. Cindy Shaky's encounter did not constitute jury intimidation and did not compromise her impartiality. Jury intimidation, as I previously stated, requires evidence of coercion, bribery, or pressure to influence a verdict, as established in the Director of Public Prosecutions against Calvesta Herbert et al. Forgive me if I sound redundant, my lords and my ladies, but I just want to reinstate and emphasize this point. Shaky's interaction was completely unrelated to court proceedings. And while the appellants will try to make this honorable court believe that this constituted intimidation, we reject this argument, my lords and my ladies, as this interaction inherently lacked evidence of coercion, as there was no real threat made to Shaky. Additionally, her interaction at the supermarket did not show any signs of bribery or pressure to influence a verdict. All that was said to her was, "Girl, make sure you do the right thing." A statement said outside of court with completely no context to support or establish jury intimidation. The court should also be aware that Shaky's continued participation in the jury process without requesting removal indicates that she did not feel compromised. Her decision to report the incident to the court registrar further supports that she handled it appropriately. Further, apologies, my lords and my ladies. Further, on hearing Shaky's interaction, the judge correctly exercised his duty when summing up the evidence and without mentioning the encounter to the entire jury panel, instructed them to stick to their oath and make their decision based on what they heard in court, which they did indeed do. However, my lords and my ladies, should this court disagree with this argument, and indeed were to find that the judge ought to have conducted an investigation into the complaint, notwithstanding our submission, we respectfully submit that the judge's failure to properly investigate the complaints in this case did not render the conviction unsafe, as no prejudice accrued to the appellant. The appellant has brought no evidence before this court of prejudice against him and has failed to show that he was in any way denied a fair trial. In support of this argument, my ladies, we wish to draw a comparison to the case of the King against Sean Campbell and others. We do apologize for this case not being in our written submission, my lords and my ladies, but we do commend this authority to the court for its consideration. In this case, there was an allegation of jury intimidation, and that juror was dismissed. The judge did not conduct an investigation, but instead reminded the jury of their duties. The Privy Council held that while this may have been inappropriate, it was not a material irregularity, because no prejudice accrued to the appellant. Similarly, in this case, we submit that there was no evidence of prejudice to the appellant. And therefore, my lords and my ladies, that if this court is of the view that the judge's failure to investigate the situation could be described as inappropriate, it was not a material irregularity, and therefore did not render the conviction unsafe. On this basis, my lords and my ladies, we submit that the judge properly exercised his discretion in this particular circumstance by not discharging the jury because of the complaint made by Shaky. And further, if this court were to find that the judge did err by not conducting a proper investigation, we reinforce the fact that the discharge of the jury would still not have been appropriate in these circumstances, as there was no material irregularity. For all the foregoing reasons, honorable justices of appeal, we submit that, firstly, the identification evidence of the witnesses reinforces the safety of the conviction. The circumstantial evidence relied on by the prosecution is sufficient, or was sufficient rather, to ground the conviction. Thirdly, the judge exercised proper discretion by not discharging the jury after a complaint was made by a juror. For all these reasons, my lords and my ladies, Parker's appeal should be dismissed and the conviction should stand. Unless there's anything further that we can assist the courts with, this is the extent of our submission.
Thank you.
Thank you.
Grateful, my lords and my ladies.
And call counsel for their able submissions.
Right, good. Yes.
Yes.
Well, contestants, good afternoon. Well, it's a good evening now. We've had a very enjoyable evening. As a bench, we've discussed your presentations, and I must say we found you all very, very good, very professional, and you know, your prospects look good. One or two are a bit shaky. You need to brush up sometimes on your authorities, and some of you need to read the facts a bit more precisely, but on the whole, as a bench, we thought they were very commendable. We can see you put a lot of effort and hard work into this, so you should all be very pleased with yourselves. Unfortunately, everybody can't be a winner, but you are all winners. Only some of you will be going forward. We have taken our time through our findings. We've listened to you very carefully, and I guess you're dying to know what the position is. In terms of the best, the most best we found is through, not through collaboration, we all vetted you individually, then we put our scores together. Now, in terms of the respondents, we found you all very good, but we found that team 108, they were the best. They got the highest score. It's for the respondents. And who is 108?
Can you just stand?
Oh. And in respect of the appellants, we thought team 101 were the best. Oh yes. So,
101 stand?
yes, stand. The women. But the others should not feel discouraged. And in terms of how we scored you, we found that Miss is Adia Daniel. Miss Daniel, who's Miss Daniel? We found you were very good. You got a very high score on the individual basis. We found you were very good, and that's all of us. That's correct? Yeah. There's only one little thing I have to say. It is inappropriate, it's not politically correct to tell someone on the bench that they're beautiful, because it made me feel ugly, you know? So, that's a joke, laugh. No, you have to be careful. I think it was Mr. Kaiser. Yeah, I know it's probably nerves that made you say it. So just.
But in 2025,
it's
sir,
inappropriate.
As a male
talk to him.
barrister who has been practicing for some time in multiple jurisdictions in North America as well as in the Caribbean, I know it's well-intentioned, but it will be looked down upon, and we are functioning in a context, at least for me, in North America, where the vast majority of judges are female. It is, yes, it's seen as pandering, and yeah, I've actually seen counsel.
Oh, sorry.
I've actually seen counsel being upbraided for such comments. So I would strongly advise you to be very cautious about such things. I know it's well-intentioned, but in the climate that we're in, for good or bad, I make no judgment. It is just not. And also, you guys, at one point, I'm not trying to upbraid you. You're young, but you have to maintain the decorum and respect for the bench in terms of how you address the court. At one point you said you guys, and that's something that you ought to be careful about.
And all I would add to that, in certain jurisdictions you could be up for disciplinary, so you have to be very careful. And it's just been brought to my attention. Mr. Timothy Mathrin, who is Mr. Mathrin? Oh, stand up. We found you were very good. We thought you were the best of the male. So well done. Yes. So, thought we should give the special mention to you too, but well done everyone, and I wish the parties who are going forward for the finals all the best. Get some sleep tonight and relax and eat your breakfast before you come, so you won't be starving. Okay then? Is there anything else that you would like us to say? That's it? Well, thank you very much, and get home safely. Thank you.